All right, good morning. We're on the record. It's October 9th, 2025. This is the morning session of the Yelm Municipal Court. My name is Judge Pro Tem Chris Coker, and we have several matters on the 8:15 calendar this morning. Have looks like a couple folks in the courtroom, and then we've got some in custody. Are a little. They'll be at 8:30. So we're good to go.
Yeah, we do have an attorney and their client on Zoom for the 8:15.
Okay. We have folks in the courtroom too. Do we want to take that case first? Why don't you come forward? You're welcome. What's your name?
This is Lou Florence.
Florence. Lou Florence. Okay, this is cause number 380774874. Charges DUI. We're on for sentence compliance. And are you Mr. McGinty?
I am, Your Honor.
Good morning.
Good morning.
All right. Good morning, Mr. Florence.
Good morning.
Okay, what are we doing with Mr. Florence's case today?
Your Honor, Mr. Florence was on a review status in this court for a law-abiding behavior violation of Lakewood. That case resolved. That case had some significant issues. It resolved very favorably to us on the eve of the motions hearing. I did speak with the state today, or the city. They're in agreement. They proposed order, I guess, to extend the term of the SOC for another year, and in which Mr. Florence would still be able to receive the benefit of the bargain under the current SOC. He's completed everything that's listed in that original SOC. I think it's the victim impact panel wasn't filed. I believe STEP filed that earlier last month. I hope the court received that, but does understand what needs to be done here to get the benefit of the bargain. And I believe he's willing to extend jurisdiction here and waive his right to a speedy trial, knowingly voluntarily indulged. Thank you.
All right, thank you. Anything from the city on this case?
No.
All right, so Mr. Florence, just based on what Mr. McGinty indicated, we're going to extend the recommendation. Basically, you know, by extending this a year, that's a contract. So the city doesn't have to do that. So the city is giving you another opportunity to kind of get compliance, I guess, for lack of a better way to put it. So you've got an opportunity here. So
I get it.
Yeah. So okay. All right. So we'll go ahead and extend it 1 year. Let me make sure is in the order. Does that have the new date on the order? So do we know what date that would push it out to, Ratfield? So let me see. No, it doesn't have the date on there. Madam Clerk, know what the current date of what's the current?
It was to end in April
Of
this year,
Okay.
April 25th.
Okay, so we extended a year from today's date?
Think of a year from today's date. That's fair.
Okay, so if we can, on the modification of it, continues to extend it for 1 year so it'll give it a new completion / satisfaction date of October 9 of 2026. All prior conditions remain in effect. All the conditions of the stip and order are still applicable. Any reason for review at this point other than just for new law violations? Okay.
No, it was just this year.
Okay, so we will, again, you won't have any reason to come back so long as you're in compliance. And everything stays copacetic. This case will come up for review a year from today. And if everything's good, you'll get the benefit of the deal. Okay. All right. Anything else on this matter, Mr. McGinty?
Nothing further. Thank you.
All right, gentlemen, thank you.
Thank you, Your Honor.
Yep, have a good rest of your day. And Mr. McGinty, you'll be able to get a copy of this at the front desk.
Perfect.
All right, thank you. Very good.
Good morning, Your Honor.
And good morning, Your Honor. Austin Onsing on behalf of Mr. Barriga as well.
Good morning. This is cause number 4A009933. City of Yelm versus Daniel, am I pronouncing that correctly? Barriga?
Yes, Your Honor.
City of Yelm versus Daniel Alexander Barriga. This is on for DUI compliance, for a diversion, on for review. We have Mr. Is it Ansing?
Onsing, Your Honor.
Present with, via Zoom with Mr. Barriga. What are we doing today, gentlemen?
And Your Honor, I just provided the city with, and it was just this morning, so I'm sure they haven't had the chance to fully review everything, but it did provide the city with an update for his treatment compliance regarding his PTSD treatment that he's completing with the VA, which was pursuant to the pretrial diversion agreement, and then also completion of his DUI victim impact panel. I'll get those filed with the court as well, but I have filed proof of those via email with the city this morning.
Okay. And did you send those just to the court or to the prosecutor as well? Probably just the court, I would think.
I just sent them to the prosecutor this morning. I can email them to the court though.
Sounds like he's got them. So was there any other issues with compliance other than that? And maybe Mr. Barriga getting too many tickets in June, speeding tickets and moving tickets, but I'll let you deal with that, Mr. Barriga. So, anything else in terms of compliance with this particular case?
No.
Okay. City's intent is then just to leave this matter.
Leave it open.
Leave it open. So, all right, Mr. Barriga, based on the fact you've gotten into compliance, what's that? Oh, based on the fact you're back into compliance, the city's requesting just to leave the proposed resolution, which is the stipulated order of continuance or diversion agreement in place. So maintain the conditions and hopefully we won't see you back here again, okay?
Yes, Your Honor.
Mr. Onsing, anything additional?
That was my only matter today. Thank you, Your Honor.
Good rest of your day.
You too. Thanks, counsel.
Okay, let me just. Do we need to do an order on Barriga?
No.
Okay, just because nothing changed?
Yeah.
Okay. All right, so we'll come back to the 8:15s. Can you mute for 1 second? All right, back on the record, Nisqually Jail, I see a door. Well, Mr. Havergal, he'll be there too, right?
Yes, he's,
Okay,
he said that he's there.
okay. And then we'll deal with the getting Mr. Havergal on the camera issue.
Yeah.
Is a weekly or bi-weekly occurrence. Am I on the camera? No, I see your tie.
Come on in. It's a small room. Yeah, let's have a seat. See. This, yeah. Okay.
All right, good morning in the jail. Mr. Havergal, I can see your coat and the top of the defendant's head.
Right. Good morning, Your Honor. This is Christina Russell. She was arraigned on Monday and matter comes on for a pretrial hearing this morning. She would like to take care of this case. I've prepared and discussed with her a statement of defense on plea of guilty, which I've placed in O courts. And so my understanding is she wishes to enter a plea this morning, and on the hope that the court follows the city's recommendation of just time served, and her hope is she can get out today.
Can we adjust the camera down just a little bit or have Miss Russell sit up maybe?
No, give me a second.
Okay, there we go. All right, you are Christina Renee Russell?
Yeah,
Is that yes?
yes, sir.
Okay, all right, Miss Russell. What was your last level of education completed?
I did some college.
I'm just gonna add 12th grade plus on this. So, Ms. Russell, I've been handed forward a statement of defendant on plea of guilty. This is again, cause number 580692755. Allegation is reckless burning in the second degree.
Yes, sir.
You have a chance to go over this with Mr. Haverco?
Yes, sir.
And did he read it to you or did you read it yourself or a little bit of both?
We actually always read it together, no matter what.
I'm sorry, say that again?
Sir, we read it together no matter what, so so I know that what I'm aware of and what I'm saying that I'm guilty of, and that I'm aware of the whole entire situation, sir.
Ahead of me, Ms. Russell. Hold on 2 seconds. So I understand that, but you did read it through with Mr. Haverco and you had enough time he answered any questions you have?
Yes, sir.
Okay. All right. I'm going to go over a couple high points here. Paragraph 5 contains a number of constitutional rights that you're giving up by pleading guilty. Do you understand that?
Yes, sir.
And this is reckless burning second degree is a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. You understand there's a recommendation contained in this agreement that I don't necessarily have to follow. I could sentence you up to the maximum.
Yes, sir.
All right. So at paragraph 11, there's a typewritten statement that states on August 12th, 2025 in the city of Yelm, I started and tended a fire under the bridge near Yelm Tenino Trailhead because of dry conditions. This recklessly created the risk of the fire spreading to other structures and potentially the bridge. Is that your statement?
Yes, sir.
So, Ms. Russell, as to the charge of reckless burning second degree, how do you plead? Guilty or not guilty?
Guilty, sir.
Okay, I'll find your plea is made knowingly and voluntarily, freely and voluntarily, and no one's made any promises of any kind to cause you to enter the plea. Are we going to sentencing today?
We are, Your Honor.
Yeah, I'll hear from the city first.
Your Honor, it's an agreed recommendation, time served, and just ask that you follow it.
All right, Mr. Haverko?
Yeah, she's been in custody for a few days, and I think the parties agree that's sufficient. She is indigent, so the city's not asking for any financial obligations.
How many days credit does she have?
Well, I think she was taken into custody on the 12th, so, well, no. I'm not sure. I have to look in the docket. I'm not sure how many days she has.
On the 6th, so I'm gonna give her, okay. So she's got like 3 days credit. Okay. All right, sorry, Mr. Haverko, anything additional?
Nothing to add, Your Honor.
All right, Ms. Russell, your opportunity to say something before sentencing. You don't have to say anything. If you don't say, I won't hold it against you. Just if it's your opportunity.
No, sir, I have nothing to say, but thank you so much for everything you guys have done for me.
All right. So, Ms. Russell, obviously these for reasons that are I'm not exactly clear on. We're getting Yelm seems to get an inordinate amount of reckless burning charges.
Yes, sir.
And this is in August. I dealt with one where I held a guy in jail, I think for at least a couple of weeks when he was lighting a fire on the 4th of July going down the street. I'm going to ask, what were you burning? Why did you light a fire in August?
Honestly, I was like super, super cold, and I was like, it gets cold at nighttime. So I was just trying to get warm. And then the police officer was like, hey, there's a burn ban right now. And I was like, okay, so I try to put it out as soon as I can. Well, I guess there was other little fires or other fires that had happened right afterwards or at the same time. So, so I tried to put it out and stuff like that, but it's not like there's no trespassing, but there's like no trespassing if you continue your behavior. And unfortunately that continued on and carried on. So I guess just things, it gets cold out there when you're homeless, and when like we have a lot of people who take care of us, yeah, but it does get cold, and that's just pretty much what it was. Just being cold.
All right. Well, I just want to kind of give you, a heads up. I don't know. I haven't done a deep dive into the level of services in this town for the homeless, but I'm gonna tell you, if I'm the judge in this jurisdiction next summer, these reckless burnings are just. I mean, this is a disaster waiting to happen, and if these continue. I'm going to have no choice but to hold these folks in jail pending some resolution, because it's too much of a risk to the community. And
yeah, I think, to be honest, at this point in time, none of us really care if we get held in jail, because of how bad it is out there. It's cold out there. There's lack of food. There's lack of like socialness. Like most of us are ex-military. Most of us are ex-military wives. So our husbands, children, wherever that is, and it's killing us out here. So most of us just actually do things so we do get locked up, to be honest.
that's sad to hear.
Yeah, it is actually sad, because it is also, if it's not dealt right or handled right, then it's repertoire on us, so people think we're all this stuff like that. I was pedophile bait for a long time, and so people think certain things, but good thing I have my security, and good thing I have my home, which is so.
Well, Ms. Russell, I wish you the best of luck. I hope you can I hope you can get moving forward in some way, shape, or form from your current situation. So what I'm gonna do is this: I'm gonna impose 364 days in jail. Going to suspend 361, give you credit for 3 days, impose a $5,000 fine, suspend all $5,000 on the following conditions: no law violations, keep your address and everything up to speed with the court. Obviously, no law violations means no reckless burning.
Yeah, so we don't have addresses either, and that's the thing too, it's like honestly, the people that serve the country is like, it's frustrating because what we didn't get taken care of, like we're outside, you know? And whether people like to, you know, like it's just like, I don't know, like how would you feel? You know, it's like really frustrating. I wanna cry too, it is, okay, thank you so much.
Position to be able to deal with those kind of bigger issues at this point. I just hope, you know, that if people are doing things intentionally to get arrested, there's other ways to get arrested other than, you know, potentially starting a fire that could cause massive damage. So, all right, I wish you the best of luck. And I'll go ahead and sign this order.
Yeah, thank you so much, I appreciate it.
Thank you. Mr. Haverco, anything additional with Ms. Russell?
Oh, nothing else, Your Honor. Thank you.
Thank you.
Are you, no?
We want to call the 815s really quickly. All right, City versus Naapua Elisara, cause number 6Z033039, assault 4th-degree. SOC was to end on May of 2024. They still owe $250 and there was a new law violation.
Issue $50 to
$1,000 cash or bond. Toby Thomas Hilton, cause number AZ0924298, theft third. New felonies, bunch of new theft charges. 5,000 cash or bond. Paul Reed, cause number.
He's gonna submit a request for a reset or extension. He just got a new job.
Okay, it looks like he has no new law violations, owes $250. I'm gonna kick it out.
Yeah, let's reset it.
Reset it out, normal course for Mr. Reed. And then that resolves the 830s or 815s. Yeah, let's give Dan a second to come out and do it. get in the attorney between the next one. All right.
This is, good morning, Your Honor. This is Gilberto Rivero. He has two matters. It's all the same incident. But he has two cause numbers. They both come on for arraignment this morning. I have discussed with him what an arraignment is. And he would like to waive arraignment and pursuant to that, enter pleas as indicated in the statement of defendant on plea of guilty, which has been placed in O courts and with which I've discussed with him. So we're ready. We'd like to enter pleas today.
Okay, you are Gilberto Rivero?
Yes, sir.
Good morning, Mr. Rivero. This is cause number 580203260 on for arraignment, as well as 580203261 also on for arraignment. Been advised by counsel that your intent is to plead guilty this morning. Let me see what we've got. So before, in all courts, I have a statement of intent on plea of guilty. Mr. Rivero, what's your highest level of education you've been through?
Past college, a little bit of military training.
Okay, so Mr. Rivero, looks like there's a plea here. Your intent is to plead guilty to a use of delivery of drug paraphernalia, operating a motor vehicle without ignition interlock, and failure to obey a police officer. In exchange for acceptance of those pleas, the city would move to dismiss count of controlled substance knowing possession and a driving with license suspended third degree. Is that your general understanding?
Yes.
All right, have you had enough time to go over this plea form with Mr. Haverco?
Yes.
And did Mr. Haverco read this to you, or did you read it yourself, or both?
Both.
All right, so I'm going to go over a couple highlights of this. Paragraph 5 contains a number of constitutional rights. You understand if I accept your plea, those you're giving up those rights?
Correct.
And at paragraph 6, use of drug paraphernalia is a misdemeanor. Maximum penalty is 90 days in jail, $1,000 fine. Operating motor vehicle without ignition interlock is called a gross, and failure to obey a police officer are both gross misdemeanors, which means the maximum penalty is 364 days in jail with a $5,000 fine. You understand that those are the maximum penalties, and I understand that there's a recommendation contained in this agreement, but you understand I don't have to follow any recommendation. I can sentence you up to the maximum on each.
Correct.
Okay. All right. Paragraph 11 states on February 8th, 2025 in the city of Yelm, the following occurred. I drove a motor vehicle without ignition interlock device as ordered by the Department of Licensing. I willfully failed to comply with the Yelm police officer's signal to stop my vehicle, and I possessed paraphernalia, a scale, and some baggies I had used to store and consume controlled substances, in this case, fentanyl and methamphetamine. Is that your statement, or are you adopting that statement, Mr. Rivero?
Yes.
All right. So as to the charge of delivering drug paraphernalia, how do you plead, guilty or not guilty?
Guilty.
And as to the charge of operating a motor vehicle without ignition interlock as ordered by the Department of Licensing, how do you plead, guilty or not guilty?
Guilty.
And as to the charge of failing to obey a police officer, how do you plead, guilty or not guilty?
Guilty.
All right. I'll find all three pleas are made knowingly and voluntarily. No one's made threats or promises of any kind to get you to enter the plea. And are we going to move to sentencing today?
We are, Your Honor.
Okay, I'll hear from the city first.
Your Honor, it's an agreed recommendation. That's the follow.
All right, Mr. Haverko.
Agreed recommendation, Your Honor, credit for time served. He is indigent city, I don't believe, or if they were, ask the court not to impose any financial obligations.
All right, Mr. Rivero, anything you'd like to say before sentencing?
Probably off the top of my head, just not really. Thank you for hearing me out. And
Okay, all right. Okay, Mr. Rivero, I'll follow the recommendation. I'll impose under the 5A0203261 use of deliverers to drug paraphernalia, impose 90 days in jail, suspend all 90 days, impose $1,000 fine, suspend all of the fine, a period of 12 months. I'll dismiss 5A0203260 charge of DWS third. As to 5A0203260 operating motor vehicle without ignition interlock, I'll impose 364 days in jail. How long have you been in jail, Mr. Rivero? You know when you,
I'm not even sure.
do you know, Madam Clerk?
Yes, on October 6th.
October 6th, all right. We'll suspend 361 on that. And give you credit for 3 days served. Impose $5,000 fine, suspend all $5,000, again, for a period of 12 months. Under 5A0203260, failure to obey a police officer, and impose 364 days in jail, going to suspend all 364, impose $5,000 fine, suspend all $5,000 for a period of 12 months. General conditions are going to be no criminal law violations. Make sure you appear at all court hearings. And, you know, no other conditions, Mr. Rivero, other than I hope you can, you know, get things figured out to the extent you need to get things figured out. You know what I mean? So, and it does look like you've got a warrant out of Bremerton Muni, for a DUI back in 2021. So when you get out, you're probably going to want to give them a call and figure out a way to get that quashed.
Okay.
All right. Anything else on Mr. Rivero's case, Mr. Haverko?
Nothing else, Your Honor. Thank you.
All right, Mr. Rivero, good luck.
Thank you, Judge.
All right. Do we want to take the lawyer on?
So it's true for
All right. Good afternoon.
Morning, Your Honor.
Good morning. This is the Robinson, Christopher Carl Robinson, 4A0035381. Are you Mr. Woodford?
No, I am attorney Chris Wood. I work with the attorney of record, Cordero Woodford, Your Honor. I'm standing in for him this morning, representing Mr. Robinson. Mr. Robinson is currently incarcerated in the Thurston County Jail awaiting attempted murder charges. So we're just asking to continue this matter. A speedy trial waiver has been uploaded, Your Honor.
Okay. Any objection from the city?
No.
Okay. Catch up to myself here. Okay, all right. Again, this is cause number 4A0035381, City of Yelm versus Christopher Robinson. Mr. Chris Wood is present. Mr. Robinson is not present based on statements of counsel. He's in custody. So I've got a motion to continue. We're going to reset this matter to November 6th at 9 a.m. So Mr. Wood, obviously just be in touch with the prosecutor's office, and I've got a waiver that'll make the commencement date November 6th with an expiration date January 5th, first in custody versus February 4th of 90 days out of custody. Grant the motion,
Thank you, Your Honor.
and we'll see you back here on November 6th.
Understood. Thank you, Your Honor. Appreciate your time. Have a good day.
Mr. Wood? Assuming that's yes. Okay. All right. Anybody else online? You want to pull up Ms. Ganem? That's Van Winkle is number 9. Good morning, Ms. Ganem.
Good morning, Your Honor. I am here on the Van Winkle matter. I believe he is present in court.
Is there a Justin Van Winkle present? Not here yet.
Okay, I'll wait, Your Honor.
All right.
Thank you.
You're welcome. Are you here for 9 o'clock? Okay, what's your client's name?
It's Marcus Bowler.
Okay, Marcus Timothy. Do we know what we're going to do today?
I filed a motion to continue.
Okay, why don't you come forward? I just don't. We got the jail sort of on hold here. So this is cause number 580700139, City of Yelm versus Marcus Bowler. Mr. Bowler's present. Are you Mr. Rosen?
I am. Good morning, Joshua Rosen here.
Good morning. Okay, and you were going to say, what are we doing with Mr. Bowler's case today?
Judge, respectfully, we had asked for just a motion to continue. I filed the documents out of courts. I believe we put in for 60 days. I have had some reach out to the prosecution, but I understand they're looking into the case. It's still a pretty young case here.
Okay, and any objection from the city?
No, Your Honor.
Okay, so, all right, I've got a waiver, commencement date of December 4th, expiration date March 4th, assuming Mr. Bowler stays out of custody, so you get 90 days. This matter will be continued to December 4th at 9 a.m. And all prior pretrial conditions that were set remain in effect. And Mr. Bowler, I appreciate you being here early as well. And we'll see both you gentlemen here back on December 4th. You get a copy of this at the window.
Okay, yeah, thank you, Judge, and
Yep.
more to you in the city.
Yep. Van Winkle? All right, we have Mr. Van Winkle. Why don't you come forward? Ms. Ganem, we have Mr. Van Winkle as present. Yeah, go ahead and have a seat. This is cause number 580150701, City of Yelm versus Justin Wayne Van Winkle. Ms. Ganem is present via Zoom. This matter is on for pretrial. What are we doing today with Mr. Van Winkle's case?
Good morning, Your Honor. Allison Gannon present via Zoom with Mr. Van Winkle, who's present in the courtroom. Parties have reached a resolution, Your Honor, on this matter by way of a 12-month stipulated order of continuance.
All right. Okay, Mr. Van Winkle, I'm going to just go over a couple highlights of this agreement. Number one, I'm assuming you've had enough time to go over this with your attorney.
Yes, sir.
And did Ms. Ganem answer any and all questions that you have?
Yes, sir.
Okay, so the charge here is theft third degree. This is a contract. It is for 12 months. It contains a waiver, contains indication you're going to maintain law-abiding behavior. You're going to pay $150 probation fee. And basically, you do those things and you don't go on the property a safe way. At the end of 12 months, this matter, based on the agreement, would be dismissed. Do you understand that? And you understand that if you violate the conditions, you'd be brought back in and your guilt or innocence would be determined based on a reading of the police reports. You understand that? Okay. All right. Anything else from the city on this? Ms. Ganem, anything else from you?
Nothing additional, Your Honor. Thank you.
All right, Mr. Van Winkle, this is a good opportunity for you. You'll get a copy of this at the window. If you have any questions over the next 12 months, make sure you stay in touch with Ms. Ganem, and we'll hopefully be dismissing this a year from today. All right. Good luck to you. Yep. All right, Ms. Ganem, anything else for you today?
No other matters. Thank you.
You're welcome. Have a good rest of your day.
You too.
Anybody else online? Yeah, why don't you see that? I assume all you folks here are waiting for your counsel? Okay. Well, if they don't identify themselves, we'll kick them out. Okay. Oh, there we go. We have somebody on Zoom. The identifier is iPhone. Can you state, are you here for court this morning?
Yes.
What's your name?
William Gardenier.
Okay. All right, Mr. Is it Gardenier? That's right?
Yes.
All right. Good morning, Mr. Gardenier. I think your attorney, Mr. Harbison, just logged on as well. So we'll give him a second just to pop on.
Good morning, Your Honor.
Good morning, Mr. Harbison. How are you?
Good. How are you?
Good. I have Mr. William Gardenier online. This is cause number 580312288. Charge of driving with license suspended, third, operating motor vehicle without ignition interlock. Defendant and counsel are present via Zoom. What are we going to do today with this case?
Your Honor, I did file a motion to continue in all courts. We're asking for November 20th as the next court date so I can be present for a likely disposition. He does have some pending matters in Enumclaw that I'm also working with, and we're trying to resolve those cases as well.
Okay. Any objection from the city? No. Okay. So, Mr. Gardenier, I'm going to pull up the proposed motion to continue with a speedy trial waiver. We have a speedy trial waiver with a commencement date of November 20th, expiration date of February 18th of 2026. Ongoing negotiations is the and likely disposition next time. I'm going to and again, I think no objection from the city. So based on that, I will go ahead and sign this order. So Mr. Gardenier and Mr. Harbison, your next court date is going to be November 20th at 9 a.m. And all prior conditions, Mr. Gardenier, remain in effect. So we will see you back here with counsel on November 20th.
Thank you, Your Honor.
Harbison, any other matters today?
I do. I believe Mr. Edwards is there in the courtroom.
Come on, you are correct. Come forward, Mr. Edwards. This is Tyrone Michael Edwards. All right, good morning, Mr. Edwards. Cause number 580312315. Charges reckless driving on for pretrial. Mr. Edwards is present in court and Mr. Harbison is present via Zoom. What's our intentions on Mr. Edwards' case today?
It's a same motion to continue, Your Honor, for November 20th. And I'm also working with Mr. Edwards on some other matters. I believe it's going to be a likely resolution.
Yeah, just sit.
Okay. For Rafael, anything additional?
No, thank you.
All right, so Mr. Edwards, what we're going to do is we're going to continue this matter. And Mr. Harbison, I know you're not present, obviously you're Zoom, but you know, Mr. Edwards has a reckless driving, a new charge as recently as September 1st. Another reckless driving in July, another reckless drive, and then a neg driving second in July. All since the charges in this case. Mr. Harbison, are you representing Mr. Edwards in all of those matters?
Not in all those matters, Your Honor. I just became aware this morning about the new reckless driving.
All right. So we have Mr. Edwards present. He has a charge from May of 2025, reckless driving. He has a racing charge that is apparently open from July. Reckless endangerment in July. Neg driving second in July. Reckless driving in a different jurisdiction on the same day in July. And then reckless endangerment, looks like a different cause number, so same day. And now we have a reckless driving license suspended second in Lakewood on September 1st. I'm going to look at the matter in Lakewood. Have you been to, are you, and Mr. Harbison, I don't mean to drop this on you, Mr. Harbison, but I'm going to look up Mr. Edwards' case status in Lakewood, because I'm assuming somebody's going to take him in at some point. Whether it might be us, I'm not sure.
Your Honor.
I wouldn't say anything, Mr. Edwards. He had arraignment on October 7th. He had to post bond of $3,000. Mr. Edwards, I'm going to make something really clear. Because you're represented by counsel, I'm going to give you a little grace today. If you get one speeding ticket between now and the next court hearing, I'm going to make a note on the docket that you are going to be, we will issue a warrant and you're going to be taken in and held until this case is resolved. Do you understand that?
100%.
Okay. All right. All right. So I'm going to sign the order, Mr. Harbison. Resaying this matter to November 20th. I'm going to ask the clerk to monitor Mr. Edwards on at least a weekly, if not twice a week basis to see what we've got going on. I'd like an added condition to be no moving violations. That'll be part of his conditions, and not convictions or not findings, but no even charges of moving violations while this is pending. Would you add that to the motion? Okay. Okay, and Mr. Edwards, I'm going to sign this order. Stay in touch with Mr. Harbison. You got a lot of stuff going on. And okay. Hold on one second. Let me sign this, and you'll get a copy of this at the front. And again, stay in good contact with Mr. Harbison.
Yes, sir.
All right.
I'm currently taking safety.
Yeah, I'm gonna don't. I think whatever you do, talk with Mr. Harbison. All right. Good luck, and you'll get a copy at the window. Okay, Mr. Harbison, matters.
That's all I have. Thank you, Your Honor.
Good rest. Okay. All right. In the jail, who do we have?
This is Mr. Galvin. How you doing? This is was a last minute add-on, very last minute.
Charles Jess Galvin.
Yes, sir.
All right, good morning, Mr. Galvin. This is cause number 580700168, charges obstructing law enforcement officer on for arraignment. Mr. Haverko.
Well, we'd like to just proceed. I haven't had, yeah, it's just too recent of an add-on, so I would ask us to proceed with a formal arraignment. And let's go ahead and do that. I would just indicate to the court, I did inquire about income because that's going to come up in the discussion about whether or not to appoint counsel. He indicates he's on disability from a kind of a government related job. Okay, so his net income is about $9,000 a month, and so that's for the court's information.
His income is how much per month?
About 9,000 net, because he may not pay taxes on it or part of it because it's it's disability. So I think lots of times disability pay is not taxed. So he receives in effect net pay of about $9,000 a month. He would like to get released. He's a local guy. He lives in Yelm, lives near the high school. He indicated to me, I haven't had an opportunity to review jabs at all, but he indicated to me he doesn't have any outstanding warrants or anything of that nature. And so he promises that, and he indicates to me that he appears for his court appearances. So he'd like the opportunity to be released on his own recognizance and return to court out of custody.
Okay. And just for purposes of the arraignment today, Mr. Haverko, are we stipulating a probable cause?
We are.
All right. And you're Charles Jess Galvin?
Yes, sir.
All right, Mr. Galvin, based on the statements of counsel for today's purposes, I'm going to find probable cause for purposes of the charge of obstructing a law enforcement officer. And I'm going to enter a plea of not guilty on your behalf. I am going to hear from the city as it relates to conditions of release.
Your Honor, the city's fine with standard condition.
Okay. Mr. Haverko, any comment?
I couldn't hear what he said, Your Honor.
You said standard conditions.
Meaning,
assume PC release, law-abiding behavior.
Yeah, that's fine.
All right. Mr. Galvin, I'm looking at your criminal history, and so I don't really see anything in about the last 9 years.
Yes, sir.
I don't want you to tell me, but if something was going on this particular night, you're going to have to figure out what was going on or what wasn't going on, but I'm going to release you on your own recognizance.
Thank you, sir.
Under the following conditions, you're not to commit any criminal law or criminal traffic violations. I'm also not going to appoint counsel. You make too much money. So you're going to have to get your own attorney for this. Okay. So at this point, he'll be pro se until we receive a notice of appearance if he chooses to hire counsel. Okay.
How long do I have to get an attorney? Oh, they'll set it out. Like your pretrial will be in another 2, 3, 4 weeks. Oh, okay. So yeah, you don't have to get one like today. Okay. Yeah, you're okay. Okay. Yeah, that's all right. I'm gonna have to give him at least, 3,000 or 4,000 up front. Probably. Oh, shit, I don't got that kind of money. Try my best.
So I'm not going to find him eligible for court appointed counsel. All right. So Mr. Galvin, your next court date is going to be December 4th at 9 a.m.
It gives me a little bit of time. Thank you.
You appear timely at all scheduled court hearings. You don't have any criminal law violations, and you keep your address up to date with the Department of Licensing. And these conditions will be in the order you're going to receive. If you are going to hire an attorney, I suggest you do that sooner than later.
Yes, sir.
Then they'll know what to do, and we'll go from there. Okay. Any questions? I assume that's a no. So I've signed the order. Mr. Galvin, we'll see you back here on December 4th. I wish you the best of luck.
Thank you very much, sir.
Okay. Anybody else online? Lawyer, what? Jeremy Knox. No, sorry, other 9 o'clock. You said number 9 or 5? 5, okay. Why don't you pull them up? All right, and then is there a Cynthia Lobo Hernandez here? Okay.
And good morning, Your Honor. For the
Good
record,
morning.
Matt Hill, present on behalf of Ms. Lobo.
580-692-750, City of Yelm versus Cynthia Maria Lobo Hernandez, charges DUI. Do you expect is Miss Lobo Hernandez appearing today, or are you appearing on?
No, Your Honor, I'll do 3-4 on this one.
Okay, all right, what are we doing today?
Your Honor, I did file a motion to continue. She got her alcohol assessment done on Tuesday, so I'm hoping to get that and get it to the prosecutor and we can talk. So I'm asking to set it for 12-4, I think, for another pretrial. This is our first pretrial.
Any objection from the city?
No, Your Honor.
All right, I've got a waiver of speedy trial with commencement date of December 4th, expiration date is March 4th, and I will go ahead and grant that order. And we're going to reset this matter to December 4th at 9 a.m.
Okay, thank you, Your Honor.
All right, is that all the matters you have, Mr. Hale?
That's all, Your Honor. Have a good day.
All right, you too. Okay, in the jail.
This is Mr., Your Honor, this is Mr. Knox. He was also a very last minute add-on.
Jeremy Juarez Knox?
Yes, sir.
All right, good morning, Mr. Knox. This is cause number 580859873, on for arraignment. Mr. Haverco.
We want to just proceed with an arraignment and then address conditions of release and counsel and those issues.
Okay. All right, we'll go ahead.
Yeah, he's not clear on what he's charged with, so if the court could just read to him what the charge is and the maximums that could be imposed.
I will. All right. So, Mr. Knox, you are charged with 2 counts of disclosing intimate images. And Mr. Haverco, are you stipulating a probable cause, or you want me to review the?
Yeah, we'd stipulate probable cause, and ask the court to enter not guilty pleas and then address release conditions.
Okay, so just so Mr. Knox is aware, there's 2 charges of disclosing intimate images. Looks like the victim is Melissa Ulrich. Okay. So those are the nature of the accusations. So Mr. Knox, I'm going to acknowledge receipt of your rights, going to acknowledge or find probable cause for purposes of this hearing only, and we will enter a plea of not guilty based on statement of counsel. Do we have a file in?
Other information, Your Honor, he does live locally. He's lived in his the home he's in for the last 4 years in Yelm. It's off a street called Crystal Court. He does promise he would make any and all future court appearances. So I don't believe he's any kind of a flight risk at all. He did indicate as a longshoreman, his take-home pay ranges between $8,000 and $12,000 a month. Just for the court's information, and but he'd like to be released and be able to appear at his next court date out of custody.
Okay, all right, Mr. Knox, I'm not going to find you eligible for court-appointed counsel based on what you make. I will, based on your lack of similar criminal history, I'm going to release you on your own recognizance under the following conditions. You're not to commit any criminal law violations. You're to appear timely at all scheduled hearings. Is the city requesting a no contact order from the alleged victim here?
Yes.
Okay, so I do think no contact with Melissa Ulrich would be appropriate. And is there going to be a separate no contact order? Are you preparing? If you can, I think, because does Mr. Knox and Miss Ulrich, did they live together before this?
Yes.
Okay, so Mr. Knox, we're going to, you're going to have a no contact, not to have any contact with Miss Ulrich, and not to go back to the residence located at the 1202 Crystal Court address.
That's where I live. I need my car. I need
That
my,
where Miss Ulrich lives as well?
yes.
Okay. What you'll be doing is you'll give me an opportunity to get a civil standby, to get some materials, a vehicle, if that's the case. That'll be in the order. You'll have to contact the Yelm Police Department to schedule that and get what you can. They'll coordinate it. It'll be up to them how much time they give you to get it, those sorts of things. Other than that, I'll just recommend if you're going to hire counsel, that you do that, sooner than later so you can get this case moving forward. Okay?
Yes, sir.
And then, next court date's going to be December 4th at 9 a.m. So if you do hire counsel, I'd have them get a hold of the prosecutor, obviously well before that date. And I'll sign that order. And then I'll also sign a separate no contact order with a civil standby. And Mr. Haverco, will you, maybe when we're done, if there's a window, you can discuss with Mr. Knox the civil standby process.
Sure.
And
Anything else, Your Honor, or
what's that?
is there anything else, Your Honor?
I think I'm just waiting for the separate no contact order to be uploaded.
Oh, okay.
Take just 2 seconds.
Sure. No problem. Yeah, of course.
Your Honor, because it's so new, I have to report on my computer yet. So, inputting the protected person's identifiers is going to be.
And have the clerk do it. Okay.
Okay. Yep. I'm closing that bit. Okay.
Just make it for a year for now. Well, it's pending yet. Obviously that's not set in stone, but that's just to give a date. Okay. Current or former spouse. I'm not worried. I'm no weapon surrender at this point. And then then the civil standby. Good to go? What's that? No, I think it looks good. Okay. All right, and Mr. Knox, the no contact order just indicates you're not to have any contact with Miss Ulrich, and you're not to go to the 1202 Crystal Court address we discussed. This is ordering a civil standby that allow you to get your materials, whatever you need to get there. You'll coordinate that with the police, and sounds like you're probably going to hire counsel on this. When you do so, just have them get in touch with the prosecutor sooner than later. Okay?
Okay, so I need to have police escort to be able to go, because I don't have any of my things. I don't even, she has my car key.
Correct. And again, Mr. Havercook can maybe answer some of those questions, but yeah, you have to get the police to escort you over there.
Okay.
All right, I've signed the order. Good luck to you, Mr. Knox. Okay, anybody on Zoom? All right, we have anybody ready in the courtroom? All right, come forward, Mr. Reyes. This is cause number 5800688090, City of Yelm versus Fernando Reyes. Are you Miss Polly?
I am, Your Honor.
Good morning.
Good morning.
And what are we doing with Mr. Reyes's case today?
We have reached a proposed resolution after a lot of negotiation. We appreciate very much the prosecutor's time and attention on this matter. I've uploaded a stay of charges form into O courts. It contemplates a 5-year stay with an ultimate amendment to negligent driving in the first degree.
Okay, and you are Fernando Reyes?
Yes, Your Honor.
All right, Mr. Reyes, I have before me what's called a stipulated order of continuance. Did you have enough time to go over this with your counsel?
Yes, Your Honor.
And did she answer any questions that you have about it?
Yes, Your Honor.
Okay, so basically, I'm just gonna go through some points on this. This is an SOC, which is a stipulated order of continuance for a period of 5 years. During that time, you're going to obviously stay out of trouble. You're going to pay a probation fee of $250. You're going to pay a CCR fee of $250. So a total of $500 in fines and costs. You've indicated there is a waiver of speedy trial through January 7th of 2031. The conditions are going to be, you're going to make all court hearings. You're not going to have any criminal law violations. You're not going to drive without valid license or proof of liability insurance. You're not going to drive or be in physical control of motor vehicle with alcohol concentration of 0.08 or a THC concentration of 5 to 90 grams per milliliter. You're not going to have any alcohol related infractions. You're not going to refuse to submit to a breath test or blood test upon request of law enforcement. You're not going to refuse any alcohol or drug test upon request of the court, probation, or treatment. Keep your address up to date with the court. You're going to comply with any DOL rules that are coming from this, and you're going to obtain an alcohol drug evaluation and complete any treatment that's required, and you're going to complete a DUI victims impact panel. Has the alcohol evaluation been done?
That's exactly what I was about to tell the court. Mr. Reyes has completed his evaluation already. He's
Okay.
completed his treatment already, completed his DUI victim impact, and then even did an additional substance use disorder class through JBLM. I will have my office file with all of that today.
Perfect. Thank you. All right. And so, Mr. Reyes, if you do those things and at the end of 5 years, this matter will be brought back up, and this case would be amended to a neg driving first degree. Okay. If you violate any of these conditions, you'll be put back on for a review, be ordered back into court, and then we'll have a discussion about what the city wants to do with the agreement. If it's a significant violation, the city could revoke it and move forward with the DUI. Do you understand that?
Yes, Your Honor.
Okay. All right. I will go ahead and sign this order, and Mr. Reyes, good luck to you. Have you guys grab a copy at the window. Is that the only matter you have?
That's the only one. Thank
All
you,
right.
Your Honor.
Have a good rest of your day.
Hey, Your Honor.
Yes.
Hey, Judge.
See you, Mike.
So just to update the court on the proceedings this morning, as to Lisa Carey, I was able to speak with her over the phone, but apparently this morning, I don't know whether she's detoxing or what's going on, but she didn't want to come to court, so she wouldn't come out of her cell.
Okay.
And then on Mr. Bowman and Mr. Furtwang, where they apparently were bailed.
Yes.
Released last night, they bailed out, so I think we've addressed all the people on the in custody calendar that are present.
Okay.
My suggestion on Ms. Carey would be to just set it over to the next court date. Or just to set the pretrial over.
Yeah, and that would be 2 weeks. So I assume, yeah, so I think we'll set it to 2 weeks.
Yeah.
Okay, and then what we'll do is we'll just make a note on the docket that Miss Carey refused. If she refuses again, at that point, then we'd talk about a drag order. So to get her in.
Okay.
Okay. All right. So that'll conclude the in custody. We'll see you over here in a few minutes.
Thanks, sir.
Thank you. Okay. Oh, got it. I'll sign that. Can you put on there that if she refuses one more time, that there'll be an order directing the jail staff to use any and all reasonable means to bring her to the holding cell for court. Something along those lines. The non-PC is, it's called a drag order. So, okay. And then is the Carrie ready for me to sign yet? Okay. Finish that one, then we'll do that one, then we'll do Moeller. All right, this is cause number 5A0150698, City of Yelm versus Stephen Moeller. Based on the city's statement, city making a motion to dismiss with prejudice?
With prejudice.
Okay. Any no contact orders need to be lifted or anything like that?
So.
Okay.
Nothing that would just be,
okay.
Conditions.
Okay, charge is dismissed with prejudice. I will sign the order. All right. Mariah Foster, okay, and then it's almost 9. Have you had any word from Miss Bowden?
Just that she was running late.
Okay. All right, and then you guys are here for
Just observing.
gotcha. Okay. And what's your name?
Giovanni.
What Giovanni? With a G. What time are you here for court? Oh, okay. Well, you're early. Thank you for being early. Yep, and if you're waiting, Ms. Haverco's on his way over. So just sit tight. He'll be here in a few minutes. Okay. Crystal Webb. Hearing no response. On Webb. Okay, so we still on the record?
Yes.
Okay, so Mr. Ratfield, we have cause number 5806625556, City of Yelm versus Crystal Serena Webb. We have a motion to continue that magically appeared. She's represented by counsel, Mr. Smith. Proposal is, it's got a waiver, speedy trial commencement date November 20th, expiration date February 18th, 2026. Proposals to reset this matter to November 20th at 9 a.m. Any objection from the city?
No, it's agreed, and I'm in contact.
Oh, okay, good. All right, I'll sign the order. All right. We have the Mariah Foster matter. Is that ready to go?
It might be your.
Yeah, it is.
Okay, let's come forward.
She's still working.
Maybe a couple more minutes.
Okay, all right. Anybody, any counsel online?
No.
Okay.
9:45.
What were we? Oh, right, and that's a Haverco case. All right, folks, we'll just sit tight. We're just gonna wait for Mr. Haverco and then we'll be move through the calendar. All right. Back on the record, cause number 5A0628330, City of Yelm versus Mariah Brooke Foster. Ms. Foster is present in the courtroom with counsel, Ms. Bowden. What are we doing with Ms. Foster's case today?
Your Honor, I believe the city's amending the DUI to that of a negligent driving in the first degree. And I have gone over a plea form with my client and we're asking the court to allow her to plead guilty to the amended charge and sentence.
All right. You are Mariah Brooke Foster. And Ms. Foster, what's the highest level of education you've completed? Okay, so I have before me a statement of defendant on plea of guilty to a proposed amended charge of neg driving first degree. Did you have enough time to go over this with Ms. Bowden? All right. And did she read it to you or did you read it to yourself or both?
We went over the plea form.
Yeah, did she read it to you or did she just give it to you for you to read or kind of a combination of the two? Okay. All right. Okay. And is the city making a motion?
Yes, Your Honor. City moves to amend to neg one.
Okay. All right. So Ms. Foster, I'm going to go over a couple high points of this. Paragraph 5 contains a number of constitutional rights you're giving up by pleading guilty. Do you understand that? And I need to answer out loud. Okay. And neg driving is a misdemeanor, which means the maximum penalty is 90 days in jail with a $1,000 fine. You understand there's a recommendation contained in this agreement, but I don't have to follow that. I could technically sentence you up to the maximum. Do you understand that? Okay. Paragraph 11 states, in the city of Yelm on August 8th, 2025, I operated a motor vehicle in a manner that is both negligent and endangers or is likely to endanger any property when I went into oncoming traffic and my driving was dangerous after consuming alcohol. Is that your statement? Okay. So as to the charge of neg driving first degree, how do you plead? Guilty or not guilty? Okay. Find your plea is made freely and voluntarily. No one's made any threats or any promises of any kind to get you to make the plea. Are we moving to sentencing today?
Yes, please.
Okay. All right. I'll hear from the city first.
Your Honor, we just, city agreed recommendation, all time suspended.
All right. Ms. Bowden.
Your Honor, my client is scheduled for her assessment on Monday. And she can do whatever she needs to do for follow through. She's been in a real tough situation. She's living in a camper trailer. Son, she had to send to family to take care of. She's been actively looking for employment. And she gets food stamps. So I would ask the court to consider a Blazina argument. When I asked her how she was able to pay me anything, it was grandmother sends her money once a year for her birthday. And I'm closing out my show after today too. She is actively looking for work, and she's doing the very best she can. This is a terrible mistake she made. She's not going to make it again. I also have an order, Your Honor, signed off by the prosecutor. And I would note, she doesn't have history. I think this is an isolated incident. I'm sure after everything she's been through, this that certainly won't repeat itself.
Okay. Does the city have any comments on the order?
No, Your Honor.
All right. Well, I'll sign off on this just based on the fact that the city has no objection. Ms. Bowden, I'll give you a copy of this. I'll give you this original back. Thank you. Okay. All right, Ms. Foster, you don't have to say anything. Is there anything you'd like to say before sentencing? If you choose not to say anything, I won't hold it against you. It's just your opportunity. All right. We'll go ahead and follow the recommendation. Pose 90 days in jail, suspend all 90 days for a period of 24 months. I'll impose a $1,000 fine. Actually, misdemeanor would be 24, 12. Yeah, okay, 24 months, $1,000 fine. I'll suspend all $1,000 based on statements of counsel. I won't impose any fees or costs related to this case. Ms. Foster, for the next 24 months, you're to maintain law-abiding behavior, meaning no criminal law violations. Not you're to appear at all scheduled court hearings. I'm going to indicate here you are to not drive without valid license, proof of liability insurance, not to have any alcohol-related infractions, not to refuse to submit to a breath or blood test upon law enforcement requesting it, not refuse any alcohol, drug test upon request of the court probation or treatment provider. You're to get an alcohol evaluation, which that sounds like it's scheduled for tomorrow. You're to do any treatment that's required. You're to file proof within 90 days. You understand that?
Proof of within 90 days of the assessment.
Okay. I'm also going to order you to do a victims impact panel as part of this. Again, I'd like to see that completed within 90 days. Anything else from the parties that I'm missing?
No, thank you very much.
I'm going to just mark, again, we'll see what happens with DOL, but if DOL imposes some requirements, you're to comply with all conditions that DOL would impose. All right. Okay. Ms. Foster, I'll sign this order. And Ms. Bowden, there'll be a copy of this at the window for you and your client. Good luck to you.
Thank you, Your Honor.
Thank you. Perfect timing, Mr. Haverko. You want to take I appreciate it. We'll take the Timothy Thorne case on Zoom. All right. And warrant quash? Or they already been quashed?
Yes, he paid the warrant question.
Okay. It's on the 9:45 calendar, Mr. Haverko. Timothy Thorne, he's present.
Gotcha.
Mr. Thorne, can you turn your camera on Zoom, please?
Yes, sir. Let me figure it out. I don't know. Oh, yes, sir.
There you go. Thank you. All right. You are we on the record? All right. You are Timothy James Thorne.
Yes, sir.
All right. Good morning, Mr. Thorne. This is cause number 2A018-3352 and 2A018-3353. Mr. Thorne is present via Zoom there was a warrant here, but they were quashed. And so these two matters are on for arraignment. They're number 1 and 2 on the 9:45 calendar, Mr. Haverko.
Well, I don't have any background information on the case, but we would stipulate to probable cause and as the court did in the guilty pleas, it's all the same incident. It looks like it's quite a bit of an older case at this point. I don't have any information on his financial situation.
Okay. Mr. Thorne, we appoint Mr. Haverko for the purposes of this arraignment today. So based on Mr. Haverko's statements, I'm going to waive further reading of your rights, and we're going to find probable cause as it relates to the charges, 2 charges under 2A018-3352 and 1 count under 2A018-3353. What's your financial situation? My understanding, Mr. Thorne, is you're currently on EHM?
Yes, sir.
Pierce County?
Yes, sir.
All right. Are you working?
No, sir.
Do you get any state assistance or anything at this point?
Right now I get food stamps. That's it.
All right, I'll find Mr. Thorne eligible for court-appointed counsel at no cost to him.
Mr. Thorne, do you happen to have a phone number you could share so I can contact you later?
Yes, sir. 253-427-0923.
Thank you.
Thank you, Mr. Thorne. All right, Mr. Radfield, conditions of release.
Your Honor, besides standard conditions, just ask that Mr. Thorne does not return to scene scene of the alleged crime on Desert Canyon.
Okay. Mr. Haverko?
No objection.
All right, Mr. Thorne, you're currently, how much EHM time do you have?
So I still have, I'm out of DOC custody in February.
Okay. All right, so Mr. Thorne, I'm going to release you on your own recognizance following conditions. You're to appear at all timely at all court hearings, no criminal law violations, keep your address and everything up to speed with us and the DOL. You're not to have any contact with Desert Tanning. Is that a local business? And I assume, is that gonna be an issue?
No, sir.
Okay. I'm going to appoint Mr. Haverko. Your next court date is going to be December 4th at 10 a.m. Sounds like you'll still be on EHM at that time.
Yes, sir.
Based on that, I'll preemptively approve, so long as there's no new law violations, if there's law violations, I assume he'll probably be in custody.
Right.
But I'll pre-approve you for Zoom appearance at that time, Mr. Thorne, okay?
Okay.
So you're gonna get a copy of this. We'll email it to him. Do we have a good email for him?
Yes.
Okay, so December 4th, and you're gonna get a copy of all these things, 10 a.m. Stay out of trouble, do what you need to do on EHM, and we'll see you back here on the 4th, okay?
Yes, sir. I do have a quick question. So for these cases, I went to prison in 2002, and it was under a global resolution with King County, and I've already been hit with the fines for these crimes.
What I'll do is, Mr. Haverko, I'm sure when you talk to, because you have Mr. Haverko, you're gonna get information on how to contact Haverko. He's gonna contact you. You're gonna talk with him about those issues. He's gonna talk with the prosecutor about it, then you guys can work something out.
Yes, sir.
All right. Anything else on this case?
No, sir.
Okay, Mr. Thorne, thank you. Have a good
Thank
rest. Okay. Now we'll move to the 10 a.m. calendar. Mr. Haverko, do you want to call the calendar? Or do you want me to call it?
Yeah, I'll call it.
Okay.
This is Mr. Steele.
Devin?
Yes, sir.
Okay. All right, this is.
He's signing a plea statement, which is now.
Okay.
Courts. Yeah, so he's gonna be entering a straight plea to count 2 interlock. On plea, city will move to dismiss, suspended driving third, and then we'd like to be heard as to financial obligations.
All right. You are Devin Steele?
Yes, sir.
All right, good morning, Mr. Steele. What was your last level of education completed?
13th grade.
Okay. GED or anything?
No, sir.
Okay. All right, I've been handed forward a statement of defendant on plea of guilty to 1 count of operating motor vehicle without ignition interlock. This is under 5A07-00140. If assuming that plea is accepted, the city would be moving to dismiss the accompanying charge of DWS 3rd degree. Do you have enough time to read through this document with Mr. Haverko? And did he read it to you, or do you read it, or both? Okay. And any more questions for him, or you think you're ready to proceed?
Proceed.
Okay. All right, paragraph 5 contains a number of constitutional rights. You understand you're giving up your constitutional rights if I accept your plea of guilty?
Yes.
All right. And operating motor vehicle without ignition interlock is a gross misdemeanor, which means the maximum penalty is 364 days in jail, $5,000 fine. There's a recommendation contained in this agreement. You understand I don't have to follow that. I could sentence you up to the maximum.
Yes.
Okay. All right. Paragraph 11 states, on August 8th, 2025, in the city of Yelm, I drove a motor vehicle without an ignition interlock device as ordered by the Department of Licensing. Is that your statement?
Yes.
So as to the charge of operating a motor vehicle without ignition interlock, how do you plead, guilty or not guilty?
Guilty.
Okay. Find your plea is made knowingly and voluntarily, no one's made any threats or promises of any kind to get you to enter the plea. And with that, I will dismiss the DWS 3rd charge. We're sentencing today?
Yes.
All right, I'll hear from the city.
Your Honor, it's an agreed recommendation. We just ask you to follow it.
Mr. Haverko. Asking the court to follow the recommendation with the exception of waiving any financial obligations. He is working, but he's at the same time also serving remaining 20 days on house arrest. For which court? Okay, so he has 20 days remaining on a sentence from Puyallup Municipal Court, which is expensive. So I'd ask the court to consider waiving any fines or costs. All right. Look at something really quick. Driving record's terrible.
I understand. I definitely work that, trying to fix it.
I hope so. Are you licensed now?
I have the alarm installed. I have a sub-22 insurance, but my license is currently suspended due to a ticket in Mason County from 2023. And in order to do that, it's just paying money.
Okay.
Get that taken care of, and I can suspend my license.
Okay. All right. What I'm going to do is I'll impose 364 days in jail. I'll suspend all 364 for a period of 12 months. Following conditions, no criminal law violations, no driving without license and insurance, and private, no driving without license and insurance. Maybe comply with all the rules related to the Department of Licensing. I'm going to leave the probation monitoring fee in this, Mr. Steele. You can make payments on it, but I do think there has to be, we're going to monitor this, and I think you should have to pay for that. Okay. All right. All right. Anything else from the city?
No.
Anything from Mr. Haverco? No, you're right. All right. Okay. I'm going to go ahead and sign this order. And Mr. Steele, you'll be given a copy of this at the window. And like I said, hopefully you don't drive unless you can.
Right.
All right. Okay. Good luck to you.
Thank you.
Yep. Yep. Next matter is going to be Bonnie Holland. Bonnie Holland? Yes. All right. Good morning, Miss Holland. This is cause number 580692746. Miss Holland is present with counsel on for pretrial. We have placed a statement of defendant on plea of guilty into courts, and she's going to enter a straight plea. Okay. All right, Ms. Holland, looking at a statement of defendant on plea of guilty to a charge theft third. Did you have enough time to read through this document with your counsel? And did you read it? Did he read it, or both? Okay. And theft third degree is a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. You understand there's a recommendation here that I don't have to follow. I could sentence you up to the maximum. Okay, is that yes? You have to answer out loud for the record. Okay. All right, and paragraph 5 contains a number of constitutional rights that you understand you're giving up by pleading guilty. And we talked about the maximum penalties. Paragraph 11 states, on August 3rd, 2025 in the city of Yelm, I stole merchandise from Walmart. Is that your statement? So as to the charge of theft third degree, how do you plead guilty or not guilty? Okay. Find your plea is made knowingly and voluntarily, and no one's made threats or any promises to get you to enter the plea. Sentencing today? Yes. Because she's got not a big record, but a little bit of a record. An SOC wasn't really an option, but what we'd like to do is the court to consider a deferred sentence. So with a dismissal at the end of 12 months on the condition if she have no criminal law violations. She's got, say, if you look at her history, it's really not, it's not bad. I mean, it's more than zero, but I guess the main thing is she doesn't have any prior theft-related or dishonesty-related crimes. And so she is real concerned about having a crime of dishonesty on a record that remains. So she'd really strongly like an opportunity to work and get that off of the record. She may want to address the court herself on that issue as well. All right. What's the city's position on a deferred sentence?
No.
Okay. All right. Ms. Holland, anything you'd like to say before sentencing?
Yeah, I had driving history.
Yeah. Okay. Any restitution on this case, Mr. Radcliffe? Okay. All right. Okay. I will authorize the deferral of the sentence for this 12 months. What that means is this: you're still pleading guilty today. If you get through the next 12 months and comply with the conditions, that are going to be no law violations, you're going to have to pay a $250 monitoring fee. No contact with what you're not to go to the Walmart. And basically law-abiding behavior. At the end of this 12 months, this matter will be brought back up. You won't have to come back in. It'll be administratively reviewed. If you've paid the $250 and complied in with all the other conditions, the guilty plea that we're taking today is automatically withdrawn and a not guilty dismissal is entered. Make sense? Okay. All right. Go ahead and sign this order. Ms. Holland, good luck to you, all right? Just wait a second. And you'll get a copy of this order at the window. Okay, good luck to you. Sign here. Yeah, so before you leave, just go to the window to get a copy of your paper. Yep. Next matter is Timothy Oliver. Good morning, Mr. Oliver. Cause number 580644230 on for pretrial. Mr. Oliver is present in court with his counsel of record, Mr. Haverko. What are we doing in Mr. Oliver's case today? We're going to be entering a plea. I'm going to have him sign it for a second. What's the last level of education, Mr. Oliver? 12th? Go ahead and sign right here. Have him sign this. Okay. So I anticipate he is going to enter a plea to count two, the paraphernalia charge, and then upon the court's acceptance of the plea, the city will move to dismiss the count 1 controlled substance violation. Okay. All right. You are Timothy Oliver. Okay. I have before me a statement of defendant on plea of guilty to cause number 580644230, count 2, using delivered drug paraphernalia. You have enough time to read through this document with Mr. Haverko? And did he read it to you, or did you read it to yourself, or both? Okay. And paragraph 5 contains a number of constitutional rights that you're giving up by pleading guilty. Do you understand that? And use of drug paraphernalia is a misdemeanor, which means maximum penalty is 90 days in jail with $1,000 fine. You understand there's a recommendation pretty similar to that, but I don't have to follow the recommendation. I get sentenced up to the maximum. Okay. And paragraph 11 states, on July 4th, 2025, in the city of Yelm, I possessed paraphernalia I had used to consume a controlled substance. Is that your statement?
Yeah.
So as to the charge of use of possession of drug paraphernalia, how do you plead guilty or not guilty? Okay. Find your plea is made knowingly or made freely and voluntarily. No one's made any threats or any promises of any kind to cause you to get you to enter the plea. And I'll sign this order. And sentencing today? Yes, Ron. Here from the city.
Your Honor, it's an agreed recommendation, just ask to follow it.
And it's agreed, Your Honor. All right. Mr. Oliver, anything you'd like to say before sentencing? Okay. I will go ahead and dismiss one count of controlled substance knowing possession on acceptance of the plea to the use of drug paraphernalia charge. I'm going to impose 90 days in jail, 90 days all suspended. Period of 12 months. Following conditions: you're going to pay a $250 monitoring fee. You're going to appear at all court hearings, and you're not to have any no criminal law violations. You understand that? Okay. All right. I will go ahead and sign this order, and we'll give you a copy of this at the window, and you can set up the fine payments at the window as well. Okay, Mr. Oliver, good luck. Tara Peters. Good morning, Ms. Peters. This is cause number 580692743. What are we doing with Ms. Peters' case today?
We are placing a stipulated order of continuance in courts.
Okay. All right. You are Tara Jean Peters? Yes. All right. Good morning, Ms. Peters. Before me is a stipulated order of continuance, which is a contract between you and the city. Have you had enough time to go over this with Mr. Haverco?
Yes.
Okay. And you understand that there's a waiver of speedy trial. This is a 12-month SOC, which means for the next 12 months, you're not to commit any criminal law violations, make all your court hearings. And are those the only conditions?
Yes.
Okay. If you do those things and pay a $250 fee to monitor this for the next 12 months, if you do all those things at the end of 12 months, this matter will be dismissed.
Okay.
And if you don't do that, what happens is you're brought back in, and then you've waived your right to a jury trial, you waived your right to various other constitutional rights, and your guilt or innocence would be based on myself or some other judge reading the police reports. Do you understand that?
Yes, sir.
All right. Okay. I will sign this order, and we'll get you a copy of this at the window. And good luck to you, okay?
Good luck. Mr. Revetria?
All right, this is cause number 580642777, City of Yelm versus Giovanni Revetria. Mr. Revetria is present with counsel. What are we doing with Mr. Revetria's case today?
He's going to enter a straight plea to the charge.
Okay. All right, you are Giovanni Revetria? Yes. All right, Mr. Revetria, am I pronouncing your name, last name correctly? Revetria? Revetria. All right, Mr. Revetria, I've been handed forward a statement and found plea of guilty, one count of criminal trespass, second degree. Did you read through this, or did Mr. Haverco read this document to you, or both?
Yes, we did.
Okay. And you feel like you've had enough time for him to answer any questions you have?
Yes.
Okay. And criminal trespass, second degree is a misdemeanor, which means to make maximum penalties, 90 days in jail with a $1,000 fine. There's a recommendation contained in this agreement. You understand I don't have to follow that recommendation. I could sentence you up to the maximum.
Yes.
Okay. Paragraph 11 states, on July 5th, 2025, in the city of Yelm, I entered Walmart property in violation of a previous no trespass notice. Is that your statement?
Yes.
So as to the charge of criminal trespass, second degree, how do you plead, guilty or not guilty? Okay. Find your plea is made knowingly and voluntarily. No one's made threats or promises of any kind to cause you to enter the plea. And I'll turn to the city in terms of sentencing.
Your Honor, it's an recommendation. We just have to be followed.
Okay, Mr. Haverko?
Yeah, it's agreed in this, yeah, in this instance, I don't believe the city was gonna ask for a fine because of his indigency.
Okay. And Mr. Revetria? Anything you'd like to say before sentencing? Okay.
Would like to say that
Okay. Okay. Anything else? Okay. All right, Mr. Revetria, I'm going to follow the recommendation. I'm going to impose 90 days in jail, suspend all 90 days, impose $1,000 fine, suspend all $1,000 for a period of 12 months. Following conditions: stay out of trouble, no criminal, which means no criminal law violations, stay away from Walmart. Okay. And if you do get a notice to be here, you'll appear at all court hearings. And that will be all. I'll sign this order. Okay, Mr. Revetria, good luck to you. You'll get a copy at the window, okay? Yep, good luck to you.
Next matter is gonna be Zachary Sawaya.
All right, good morning, Mr. Sawaya. This is cause number 5A06283329. Mr. Sawaya is present with counsel.
Yeah, a matter comes before the court for a pretrial hearing on a protection order violation. He's just signed a statement of defendant on plea of guilty, which we place into O courts. Ready to proceed.
All right. You are Zachary Sawaya?
Yes, sir.
All right, Mr. Sawaya, been handed forward a statement of defendant on plea of guilty to charge of one count of protection order violation. Did you read this, or did Mr. Haverko read it to you, or both?
Yeah, you read it.
Okay. And did he answer any questions that you would have about it?
Yes.
All right. And this charge is a gross misdemeanor, means maximum penalty is 364 days in jail, $5,000 fine. You understand there's a recommendation here. I don't have to follow. I can sentence you up to the maximum. And paragraph 11 states that on August 7th, you violated a domestic violence protection order by having contact with a protected person. Tiana Strait, you two were together in the same car. Is that your statement?
Yes, sir.
So as to the charge of violation of a no contact order, how do you plead, guilty or not guilty?
Guilty.
Okay, I'll find your plea is made knowingly and voluntarily. No one's made any promises or threats to get you to enter the plea. Sign the order, and we're going to move to sentencing. So I'll hear from the city.
Your Honor, it's an agreed recommendation. This has to be followed.
Okay, Mr. Haverko?
Well, last time he worked at Carl's Jr. He got fired because of the charge. So he's not employed right now. I'd ask the court to consider waiving the fine. And the other reason I'm asking the court to waive the cost is he's currently ordered out of the court where the order stems from.
Which is that Pierce County?
Pierce County, yes. And now this is one of these situations where I think he and the victim actually do want to be together. Pierce County is probably more formal. So
Yeah.
he needs to, he needs to perform and have a certain amount of progress in the DV program to get a recommendation from them. I think he's was a little confused on it. I tried to explain to him the kinds of things he needs to likely do. But to also potentially contact the court clerk up there. But so I think, I told him it's important to comply with this TV stuff in Pierce County, and hopefully he can at some point get sort of lifted, because I told him, I said, look, if you keep doing this, you're going to wind up with a felony charge.
Right.
And don't do that.
Right. All right, Mr. Sawai, anything you'd like me to consider before sentencing?
No, sir.
All right. Well, everything Mr. Havergo said is correct. I mean, there's just gonna be hoops you're gonna have to jump through. And as you can tell, if there's, a lot of these things, a lot of people thinks, well, if the protected person wants to have contact with me, well, then the order doesn't matter. The problem is it's an order from a court. So the court's gonna get all bent out of shape if you're violating something they've told you not to do. That makes sense? Okay, so you've got to get up into Pierce County and jump through those hoops, or it's not if you're gonna get caught again, it's gonna be when. Okay, all right. I'll follow the recommendation, 364 days in jail with 364 days all suspended, $5,000 fine, 5,000 all suspended for a period of 12 months. Conditions, no criminal law violations, appear timely at all court hearings. Gonna have you abide by all protective orders that are in place. And won't impose any monitoring costs at this time based on your situation. So, Mr. Sawaya, good luck to you, okay?
Thank you.
All right.
Take care. The next matter is gonna be Julie Holbrook. Matter comes on before a confirmation hearing.
Okay.
As far as I know, I think the defense is confirming. I'm not sure about the state. Oh, is that fine? Okay, because we talked about another case you wanted a reset.
Okay.
Is that the case we talked about?
Yeah.
You had mentioned the.
Well, okay, yeah, we'll need to push it out then.
Yeah, I think this is the case. Council and I spoke about the fact that I think there was some unavailability with as far as the officer goes. And other than having to come back to court again, I mean, there's really no prejudice to the defense. And so, there's a lot more speedy trial time. I don't recall what's left, but it seemed like there was a pretty substantial amount of time.
Okay.
So I would just suggest that we set a new trial date and then a new confirmation date.
Okay. Confirmation on November 6th.
November 6th confirmation.
Okay.
Okay. For a bench trial date of November.
Would this be the next 2 weeks after?
20th?
Are we running into a court date? I mean, a court date problem with the holiday at all?
No.
Or not? Okay.
Thanksgiving is the 27th this year.
Okay. Yeah, so basically, yeah. So we're just resetting. So, okay. Yeah,
All right.
sounds good.
So let's see. So confirmation date, November 6th. Bench trial date, November 20th.
Yeah, I'll just have her sign. You notice it. I have to sign. I can't do it until she's.
All right, next court date, November 6th. Confirmation date, then the bench trial will be set November 20th. And we'll see you back here on the 6th.
Well, so for your confirmation, it'll either be at 10 or 11. So just look at the order. But yeah, just, yeah.
I'll tell you 1 second. Ms. Holbrook, your confirmation or the hearing on the 6th is at 11 a.m. All right.
I have run out of cases that are ready, so let me check some meetings and see what's here.
tell them we approve the.
We could actually deal with Mr. Osborne now, if I could rather the prosecutor, because he is re-licensed.
Hey, Mr. White, this is Judge Coker. Can you hear me?
I can. Good morning, Your Honor.
Good morning. So you submitted, you were here on the web matter that was on earlier. Yeah, we got your SOC, or not SOC, the request for the continuance. We granted that. And it was reset to like November 20th.
Okay, thank you, Your Honor. Have a nice day.
Thanks for checking in. Take care. Okay, sorry.
So on the 11 o'clock, Mr. Charles Osborne.
Hello? All right.
Let me, get over there. You Charles? Okay, yeah. I'm assuming the city is going to amend to no valid operator's license with ID. They're not here, and I can go catch him, but he's relicensed.
Okay.
Pretty sure the city will be.
Let me just pull up. Are we back on the record?
Yeah.
All right, this is City of Yelm versus Charles Osborne on the 11 o'clock calendar. And let me grab. It is cause number 20250117.
I didn't check it today, but I checked it not too long ago. He was relicensed.
So I've got him on for, oh, okay. Oh, I'm sorry. Okay, DWLS. Okay.
This is Mr. Osborne, and he's on for a pre-trial hearing for a suspended driving second degree. And he's actually managed to get relicensed. And so I told the court, the city hopefully will be willing to amend to.
Yeah.
No valid operator's license.
He's got a restricted license. He's on a restricted license.
Yeah, city's gonna make that.
Okay, so Mr. Osborne, what the city does in this case is it makes a motion to amend the driving license suspended second degree in this case to an infraction of no valid operating license with ID. Fine amount $150?
Yes.
$150 court costs on that. Is that what you want to do? Okay, so we'll go and do that and so the cities know he's on another disposition on a DUI, just so you know, so out of this court. So, okay, so we'll amend it. Do I need to do an order, right? Or you'll do an order? Okay. Okay, so Mr. Osborne, I'm gonna sign a infraction disposition that is gonna detail what we just did. And amending the DWLS second to an NVL with ID, $150. And it doesn't sound like the city's, it's probably unlikely the city is going to take any action on the DUI, but just note these things, if they stack up, you might leave them with no choice. So, okay, all right. I think that's it for your case. I'll sign the order. We'll give you a copy at the window and let's just figure out how to make the payments and good luck to you, okay? Yep, thank you.
One case we could take up, I don't actually represent them if you look at the docket notes, but they're here. So it might be a good time to address this case. Caden Sadowski, why don't you come on up? And so I think the court had made, I haven't gone through the docket, so I don't recall if the court made sort of a finding that he doesn't qualify for counsel, but he had made at least a representation he was going to hire counsel. So what's that?
I haven't worked since 2023.
Oh.
We talked last time. You misunderstood what I said.
I couldn't hear a word anybody just said. What was just said?
I was misunderstood last time that I was currently working, but I haven't had a real job since 2023.
What's your monthly? You have to come on.
Yeah. Oh, okay. Well, I guess what he's saying to the quarter, he's not in a position to hire counsel, he's asking the court to consider. Okay, so I'm looking at the notes. Rested on the 18th of August. Judge Paul Meyer reviewed. August 28th, I wasn't here. Judge Hauser was present. Public defender was appointed for arraignment only. Defendant may hire a private attorney. So I'm hearing and I don't know what, that's all the notes say. So I think, I guess he would represent to the court that he makes around what, 900 bucks a month? Yeah. Doing kind of side work. What kind of work is it? Construction or? Any on any state assistance or anything? No. Any dependents? No. All right, and you said no dependents? There's no dependents? Yeah, no dependents. I believe we indicated no dependents. All right, what I can do, I'll go ahead and appoint counsel at this time. I'm gonna have Mr. Sadowski contribute $150 to that process. So I can appoint it, but it's kind of it's a modified appointment, $150 to cover the cost of the city. Okay. And then what are we going to do with Mr. Sadowski's case? I assume continue today, Mr. Haverco? Yeah. We'll need to get some kind of a phone number from you. Yeah, we'll just wait. And I'll sign this and don't leave. Yeah. You can add in that just to contribute 150. Okay, next court date will be December 4th at 11 a.m. Okay. What time do you think you have court? Oh, okay. So, Mr. Haverco, we need Mr. Sadowski just to sign one more document. Oh, sorry about that. That's okay. He's right there. Yeah. Yeah, there's one more thing I got to sign. Sorry, one more time. Yeah, here. Okay, then you just get the notices at the window. All right, thank you. And there's a 1 o'clock, I don't have any other matters ready at the moment, but I have 1 o'clock that's here, so my thought is, if the court doesn't mind, we can do 1 o'clock arrangement. I gotta go grab the file. Why don't you talk to the folks that are
Yeah,
here, and
okay,
then
that's
when we
what-
come
sure.
back, we'll throw them
Sure, you
on.
bet.
I can grab the file, so we'll be in
You bet.
recess. This is Gustavo Mendoza on the 11 o'clock calendar, comes before the court for pretrial hearing. All right. On a reckless burning charge, we placed a stipulated order continuance in the courts. All right, you're Gustavo Mendoza? Yes. It's cause number, is that yes? Yes. Okay, 5A0692737 here for pretrial. Let's see. Okay, so Mr. Mendoza, your counsel's indicated, and I'm looking at right now, what's called a stipulated order of continuance. Do you have enough time to go over this with Mr. Haverco?
Yeah.
And you understand it's contractual in nature. It's an agreement between you and the city.
Yeah,
so long as you do certain things, the city will agree to not do certain things, which in this case is not enter a finding of guilty. So this contains a waiver through January 7th of 2027. Reckless burning is a gross misdemeanor, which means the maximum penalty is 364 days in jail, $5,000 fine. This is gonna be a 12-month SOC under the following conditions. You're to appear timely at all scheduled court hearings, no criminal law violations. Any fees or costs associated with this, Mr. Haverco? $250 for the costs. Yeah, continued 12 months, condition, no new criminal law violations for 12 months, $250 costs, at the end of which time the city would then dismiss. Okay. Okay, anything additional from the city on this?
No,
Because he was with two other individuals, and basically they weren't intentionally trying to burn anything down, but what happened was they were lighting up some fireworks and it kind of sputtered and then exploded and ignited on the ground and caused a fire, and they were all pretty cooperative with police. Yeah. Okay. All right, I will go along with the agreement. Mr. Mendoza, good luck to you, okay? I'll sign this and you can get a copy of it at the window. Okay, there you go. Take care. James Papaya. Not sure if I'm saying that right. How do you say it?
Papaya.
Papaya?
Yeah.
All right, good afternoon, Mr. Papaya. Cause number 5A0644233. What are we doing with Mr. Papaya's case today? Well, if old courts would cooperate a little bit. It's gonna run a little slow. I'm gonna have him now sign a stipulated order of continuance. He has no criminal record. All right, Mr. Papaya, same thing. Same discussion I just had with previous defendant. You have enough time to go over this with Mr. Haverco?
Yes, sir.
Understand what you're doing, the contractual nature of it?
Yes, I have a ban from Walmart. That's all.
You do, that's separate. The ban from Walmart would be between you and Walmart. So you're gonna have to, I mean, you can, I don't know what the process looks like to get that lifted, but that's something you're gonna have to deal with. Okay. Maximum penalty on this is 364 days in jail, $5,000 fine. Conditions are going to be very similar to the waiver, good through January 7th of 2027. SOCs for a period of 12 months. You're going to pay $250 probation fee or fee at cost, no criminal law violations, and stay out of trouble.
Yes, sir.
All right, I'll sign this and we'll get you a copy at the window. Okay, good luck to you. Brennan Wing, come on. So we gotta do a couple of things. So he's got a couple sentence compliance cases on. He has a case that he still hasn't been arraigned on, so we need to start with the arraignment. Once we complete that, I anticipate we're going to be entering a plea in connection with the arraignment case and also the other pretrial case. Okay, you are Brennan Wing.
Yes, sir.
All right, good afternoon, Mr. Wing. Here on several cause numbers. 5A0035732 sentence compliance, 5A0642364 sentence compliance, 5A0700149 arraignment, 5A0754696 is the pretrial hearing. I've got several files. You want to start with which one do you want to start with?
Let's start with the arraignment, and on the assumption that the court's going to appoint me, he's still indigent.
I'm gonna appoint you.
Would stipulate the probable cause, but with that stipulation, I have placed that case on a statement of defendant on plea of guilty. I anticipate we're going to, as part of just a global approach here, we're gonna plea to the new arraignment case amended down to criminal trespass in the second degree. And on the pretrial matter ending in 696, we're going to enter a plea to the count one use of drug paraphernalia, and then upon the court's acceptance of those pleas, the city will move to dismiss this disorderly conduct charge. City's not asking for any costs because of his indigency, and then we'll have, you know, I guess a discussion about what to do. I don't think the city's asking for jail time, but on the sentencing matters, he was ordered to do. The issue there is some kind of an assessment, so we can have a discussion on that after the court takes the pleas.
Okay, all right, you are Brennan Wing. All right, you'd have to answer out loud for the record.
Yes, sir.
All right, Mr. Wing, I have had before me a statement of defendant on plea of guilty. It's got multiple layers. My understanding is you're going to plead guilty to 580754696, which is one count of use of drug paraphernalia. Upon acceptance, the city will move to dismiss count 2, disorderly conduct. And as it relates to 580700149, the city is amending to criminal trespass second degree. Correct. And that's 98.52.080. You understand, is that your understanding of this, Mr. Wing?
Yes, sir.
Okay, and did Mr. Haverko read this document to you, or did you read it, or was it a combination of both?
Some comments both.
Feel like you've had enough time to go over this with Mr. Haverko?
Yes, sir.
Okay. You understand you're giving up a number of constitutional rights by pleading guilty. Those are contained in paragraph 5.
Yes, sir.
And paragraph 11 states the following: occurred in the city of Yelm. On September 10th, 2025, you entered Safeway in violation of a previous no trespass notice. On September 7th, 2025, you possessed a pipe that you used to consume a controlled substance. Let's see. Which I think would cover those as to the plea, as to the charge of use of drug paraphernalia. Mr. Wing, how do you plead, guilty or not guilty?
Guilty.
And as to the charge of criminal trespass second degree, as amended, how do you plead, guilty or not guilty? All right, I find your pleas are made knowingly and voluntarily, no threatening harm to you or anybody else to cause you to enter the pleas. And we're going to move to sentencing today.
Yes.
All right.
And, you know, there's kind of a couple approaches here. It just depends on sort of what the court's thinking about whether or not how much we want to follow up on the evaluation, you know, potential kind of treatment issue. So my understanding is Mom's here. If you would mind refreshing me what efforts, if any, is made towards getting evaluated, or so we don't.
I'm not sure at all. I called him.
Mr. Wing, hold on just 1 second. Go ahead. All right.
So it sounds like his mom is accompanying him today. She's indicated to me he hasn't made any progress on that yet. She did indicate to me that there's really kind of a mental health issue. As I recall, what happened I looked up the case that ends in 364. It didn't look like at the time he pled when he was in custody that there was a treatment component imposed, but when the case, I think, came up later for review in front of Judge Hauser,
right,
it was at that point Judge Hauser imposed a treatment component on that case. I haven't looked at the docket on the older 732 case from April, but anyway, his mom would just represents that, you know, there's sort of a mental health issue going on, and so I would ask that the court
just continue oversight on the matter if the court wants to sentence him today. Again, I don't think the city was recommending jail time. I would ask the court not impose him at this time. Continue with a kind of probation and maybe then set a later review date to see if the court wants, if the court is feeling serious about imposing that requirement, maybe give him another chance to try to make some progress in getting evaluated. But I think it's tough for Mr. White. Okay, what's the city's position on all this?
Your Honor, the city isn't going to request any time, but you know, Mr. Wing is starting to accumulate quite the many months of suspended time. And so the city's position is it's going to give Mr. Wing one more opportunity, not see him again. But the suspended time is subject to not seeing him again. And so you know, this won't be the city's position forever.
All right. So Mr. Wing, what is it your position that you've done in terms of the treatment side of this?
I actually called the resources and I spoke with the person that did my review or my assessment, and he said I can get a second opinion because there's a job opportunity for me over in Lacey, and I was thinking if I'm able to land that job, then maybe it would equal, you know, to the doing the treatment, you know, so I'm like working, you know, and you know, making money for myself. I don't want to go there and pledge for that job and then have it not be satisfactory, you know.
And now you heard your mom say that she doesn't, that's your mom.
I used her phone to do it, so I don't know.
Well, I think, but Mr. Wing, hold on a second. So you've made a phone call. I remember, I think when I was here a month ago, we're kind of in the same situation. There was this discussion of getting a second opinion, if I remember correctly. And has that occurred?
What?
Getting a second opinion?
No, I'm still waiting to hear back from them. It's hard, I'm trying to catch them, you know, I might just have to sit at the library and wait for them to call or wait for email. And then, you know, right now I have a Google account. I have to make a new, every time I've made a Google account, somebody's hacked into it and freaking changed my passwords. So I can't even have a Google account to get an email. You know, it's really frustrating. Something's holding me back and it's not me. And I really firm believer in that.
Okay, well, so you did what, 2 weeks on the reckless burning, right?
Yes, sir.
And we now have a disorderly we have the criminal trespass second and the use of drug paraphernalia, I think is what we just dealt with. Why don't we do this? Why don't we hold off on sentencing today? And I'm going to reset sentencing to October 23rd. I'm going to reset sentencing 2 weeks, Mr. Wing. And what we're going to do is we're going to bring you back here and I'm going to give you, you're going to have an option. And I'll tell you exactly what that option is going to be. You come in, you have concrete proof, letter format, whatever treatment you're doing with, if you haven't started it, I want a letter that says you have an intake date. I want to see that. I want that in hand. If you don't have that on the 23rd, then what I'm going to do is I'm going to take you into custody and then we're going to hear your case at the November 6th date. So you're going to be sentenced to at least 14 days.
Yeah.
Okay. Now, if you come in with the treatment that we've been asking for now for a couple months, then we'll have a different discussion. But if you don't come in with that, I'm going to tell you, you're just going to go in, you're going to be sentenced to at least 2 weeks on the new charges. You understand that?
Yes, sir.
Okay. All right, so we'll reset sentencing to the October 23rd date. And obviously, Mr. Wing, if there's any new law violations, anything like that, that would change the scope of what we're dealing with as well. I will also tell you, I'm not going to make this a condition, but you have 3 warrants out for you.
I believe those are, I have Napline and,
Grace Harbor.
And
One more,
is it a, what's
Aberdeen.
Aberdeen?
Try to get those taken care of.
Yeah.
Okay, all right. Okay, reset this till the 23rd of October, please. And then all prior conditions remain in effect. And again, I just want to make it really clear, Mr. Wing, I want to see something in writing from a treatment provider detailing what you've done, when you're starting, or if you've started.
Yes, sir.
Okay.
Donnie, I'm assuming we're not gonna sign the JNS then, since there's no sentencing.
Right.
Oh,
Yeah.
oh, gotcha.
Yeah, the guilty plea is done. It's sentencing, and then
Oh,
then the review issues will be kicked over.
Okay. Gotcha. So go ahead and sign here, Brandon.
I don't need to sign that order, right? Not the JN, I'm not gonna sign the JNS. No, I already signed the guilty plea. I don't need to sign the notice of hearing, right? Okay.
So we doing a notice of hearing?
Yeah, I'm gonna do that for the,
One
Oh,
sentence.
okay.
And Mr. Wing, I want to believe you, okay? I really want to believe you on this.
Yeah.
And, but again, this is up to you. You're not working right now, so you got lots of time.
I didn't hear an answer on that though. Would that be sufficient if I were able to land that job and show you proof that I had the job? Versus.
I don't think you asked that, but the answer would be no, because I want to see the treatment. I'd love to see it working too.
Sign here.
So I'm not discouraging you to get a job, but I'm also not going to give you the out that if you get a job, you're not going to have to do the treatment that we've talked about.
Yeah.
Okay?
Yes, sir.
All right. We'll see. All right, Mr. Wing, good luck to you.
Thank you.
See you in a couple weeks.
Yes, sir.
Okay. All right, next matter.
Next matter is gonna be Marcus Sheets.
Marcus Sheets. Good afternoon, Mr. Sheets.
I think the city is, has a motion on this.
Okay,
Yes, Your Honor, city's moving to dismiss without prejudice.
okay,
Just the, not the infraction,
okay.
just the charge.
Do we want to deal with the infraction today, or do we not want to deal with the infraction? There's a failure to renew expired tabs greater than 2 months.
You might want to deal with that today.
It'd be up to you, Mr.
It's up-
Sheets.
Yeah.
It's on for mitigation, so it's, I don't know, I'm not looking at it right now, but whatever the fine amount is, did you get, I mean, do you want to deal with it today? We can mitigate it today. I don't know how much the fine is or whether you've gotten tabs renewed or not.
I can get it.
Okay. What's the fine amount on that? You know,
I mean, the city would recommend 150.
city'd recommend 150 fine on it. That way you'd be done with it. No, you can make payments on it. Is that what you want to do? Okay, all right. So as to the mitigation hearing under infraction number 5807-00135, the city is oppose $150 fine on that, and then he can get payments going at the window. And the dismissal on the criminal case, with or without prejudice?
Without.
Okay. All right, I've signed the order of dismissal. And then on the I'll sign the infraction disposition. And Mr. Sheets, you'll get a copy of all these at the window, okay? All right, good luck to you.
And I think we probably should call for the 12 o'clock noon matter, Sierra, Joel Navarrete, Sierra.
Is that the bench
That's,
trial?
that's a bench trial, and
Okay.
that's the case that the city and I were discussing the fact of the unavailability of its officer.
Yep.
So we don't have an objection to the matter being reset.
Okay, is it Navarrete?
It's Navarrete.
Navarrete, all right. All right, Mr. Navarrete, cause number 5803-21942, 5803-21943. My understanding is the parties, this was on for bench trial today. My understanding is based on officer unavailability. This matter will be continued for another pretrial
Just another.
confirmation.
Another confirmation of the trial.
Okay.
I think confirmation on November 6th.
We can, we are doing the whole group.
Okay.
On that day for confirmation, then 2 weeks later, we are.
Confirmation on the 23rd then.
Okay, Mr. Navarrete, we're going to give you a notice of your next hearing is going to be October 23rd, which is in 2 weeks at 10 a.m. Okay, all righty.
Wait one second.
Sign the pad. Okay. We've got the 1 o'clock, we're waiting for the pro tem for 1 o'clock. Do we want to handle, anyone else here that?
Let me just scan my 11 o'clock calendar.
The only two I have left, is there a Ashley get a can?
That's, I think is a no-show unless they showed up.
Okay, and then how, Shiana Sigby? Okay, those are only two from the 11.
Yeah, you're free to guess.
All right.
Yeah, I mean, you know, from the 10 o'clock, did Tyler Elkins show up?
I have no Tyler Elkins. Any word? What's the city's? Yeah.
No contact.
I had a phone number, called it, left a message, never heard back.
City want to have a warrant issue, just
$1,000 cash or bond on Elkins.
On Hazlet, Jacob Hazlet,
Yeah.
they don't have a phone.
We have a good address.
What's that?
Do we have a good address?
I don't know.
500.
All right, 500 cash or bond. He's got a warrant out of Centralia as well as, I don't know what WLM is, but okay, 500 cash or bond on Hazlet. Kelly Kincaid.
She was here, and I think the city.
Yeah, Miss Kincaid was here, you know, on time for 2 hours, and it seems that she left right around the noon hour. The city would just prefer reset with notice.
She was here 2 hours early?
No, she was here on time. She was here early and sat here for about 2 hours,
Right.
and then left around the noon hour. Didn't tell anyone where she was going or
She
anything.
did speak with, Sonia from Connor, so she wanted for some assistance.
Let's reset with notice.
Okay, I mean, her court hearing was 10, so.
Yeah.
Okay.
Yeah.
Joshua Patterson.
I still don't, he had given me a number, it's never been any good. So it's never worked.
500 cash or bond. Giovanni Revetria, we dealt with him.
We dealt with it.
And then Ashley get a can.
Let me see with my notes.
Steph third.
I have a number, haven't gotten return call.
Okay, city.
500.
500 cash or bond, and then last but not least, Sheann Sigby.
I had contact with her because my notes reflect I had an SOC prepared had placed into Oak Court, so she's someone who I had.
You've been in contact with her?
Yeah, well, otherwise I wouldn't have placed an SOC in Oak Court, but I haven't had new contact from her advising me she would be here.
Okay.
So I don't have any information as to her non-appearance, but I can represent to the court. I had contact with her within about a week prior to court.
She doesn't have a ton of history. Why don't we note the non-appearance and reset? We'll reset with notice to the 23rd. Will that give us enough time? They'll go November 6th. So note the non-appearance, but no warrant, just because she's been in contact. All right, I think that's it.
All right, good afternoon, everyone. Welcome to Yelm Municipal Court. We're on the 1 o'clock arraignment calendar. My name is Eric Pilon. I'll be your pro tem today. Most of you, if not all of you, are here for an arraignment. An arraignment is your opportunity to address any charges that the prosecutor may have charged you with or is intending to charge you with. Basically, at this arraignment, you will be, your attorney will be acknowledging receipt of the charges, the formal charges, and you will be given an opportunity to enter a plea. Generally, we will be accepting only pleas of not guilty at this time. A plea of not guilty will preserve all of your trial rights. You will receive some new dates for some court dates. Your next court date will be provided to you before you leave, and you will also have a trial within speedy trial. So if you're out of custody, that will be within 90 days. If you are in custody, law requires that you have trial scheduled within 60 days. When you enter a plea of not guilty, as I indicated, it preserves all of your constitutional and trial rights. Important to understand that you do have, for this proceeding and for all proceedings following this, you have the right to an attorney. If you can't afford an attorney, the city will appoint someone to represent you. You are presumed innocent throughout the whole process, up until or unless a jury finds you guilty beyond a reasonable doubt. The burden of proof will be on the prosecutor to prove that you are guilty. You have the right to a speedy trial. As I indicated, if you are out of custody, you have a right to trial within 90 days, in custody within 60 days. You have the right to have a right to a jury trial. You have a right to hear and question any witnesses who may testify against you at trial. You have the right to remain silent throughout the course of this case and throughout the pendency of your trial, as well as the right to testify if you choose to testify. You have the right to have witnesses testify for you at no expense. You also have the right to appeal a trial finding. If you are not a citizen of the United States, a conviction of a crime may result in potential deportation, exclusion from admission to the United States, or denial of naturalization. It is important you inform your attorney if that is the situation. All right. Any questions about your rights today? Okay. Let's start with, I think we have two private. All right. Ms. Bowden, are you there?
Good afternoon, Your Honor. This is Erin Foxton, appearing for Attorney of Record Barbara Bowden.
All right, so I have I'm sorry, this is number 13 on the calendar, you said? Number 14. It's nice to see you, Ms. Bowden. Good afternoon. Is there a Diana Hughes? Is that correct? I'm looking at the right calendar. All right. Is there a Ms. Hughes here today?
Yes.
Hello, Ms. Hughes. Please come have a seat next to Mr. Havako. All right, looks like Ms. Hughes is here for an arraignment. Ms. Bowden?
Your Honor, my name is actually Erin Foxton. I am also an attorney, and I'm appearing for Attorney of Record Barbara Bowden.
Apologize, Ms. Foxton.
No apology necessary, Your Honor.
Okay, so it's arraignment. Were you served with a copy of the information in this matter?
Yes, Your Honor. We are acknowledging receipt of the complaint and waiving formal reading. I believe that Ms. Hughes understands what she's being charged with and the elements of that crime, and we would like to enter a plea of not guilty.
Okay. Court will accept your plea of not guilty. With respect to conditions of release, Mr. Prosecutor?
Your Honor, just standard conditions.
Okay. All right. Pull up the order.
And no objection to standard conditions, Your Honor.
Oh, I'm sorry. Thank you. Thank you, Ms. Foxen. And Madam Clerk, when is the next court date for Ms. Hughes?
October 23rd, November 6th, or November 20th.
Okay. So I don't know, Ms. Foxton, if you've heard that, we have three available dates for a pretrial. We have October 23rd, November 6th, and November 20th.
Let's do November 20th, please, Your Honor.
Okay, counsel, any objection?
No objection.
Okay. All right, Ms. Hughes. So your attorney has entered a plea of not guilty on your behalf. The court's accepted that. That preserves all of your rights. And as I indicated before, since you're out of custody, you must have a trial within 90 days. I'm going to set conditions of release for you. These are standard conditions. Essentially, you're going to be required to appear timely at all court hearings. You're to have no new law violations while your case is pending. Any changes to your address must be updated with DOL and the courts. Do not drive without a valid license and insurance. No driving or being in physical control of a motor vehicle with a blood alcohol concentration above a 0.08 or any other drugs in your system, including THC, above 5 nanograms. Have no alcohol-related infractions either. And if you were to be in a situation where you're pulled over again and you're being investigated for a DUI, you are not to refuse to submit to a testing of breath or blood, alcohol, or else that could be a violation of your conditions of release. Did I miss anything, counsel?
No.
Okay, so your next court date looks like it's going to be November 20th. At what time? At 9 a.m. So make sure you get a copy of that order before you leave today. All right? Okay, have a good rest of your day.
Thank you, Your Honor.
Thank you, counsel. And I've signed that order. Okay. Hello, Ms. Pleasant.
Good afternoon, Your Honor. I'm here for William Steele.
All right. Number 33 on the calendar, William Steele. Mr. Steele, thank you. Good afternoon. Ms. Pleasant, looks like we're here for an arraignment.
That is correct, Your Honor. We acknowledge receipt of the complaint. We'd waive a formal reading, asked to enter a plea of not guilty. He's been advised of his rights and he understands them.
Okay. All right, the court will accept the plea of not guilty on behalf of Mr. Steele. With respect to conditions of release, counsel, standard conditions. Ms. Pleasant, any objection to standard conditions of release for Mr.
No, Your Honor.
Mr. Steele? Okay. And for court dates, it looks like we have 3 dates available. What is that? The October 23rd, November 6th, or November 20th. Ms. Pleasant, do you have a preferred date and time?
Your Honor, if I could get the November 6th date, that would work for me.
All right. Mr. Steele, one of the conditions of release is that you are to appear at your court hearing. Are you good with November 6th? And that's going to be at 9 a.m. as well? Okay. All right. Okay, Mr. Steele, the court has accepted a plea of not guilty. That, as I indicated, preserves all of your rights. We are going to set some conditions of release here. It looks like there's a joint request for, where there's a request for a no objection from your counsel regarding a release on standard DUI conditions. Just give me one moment here. Sorry, this is, it's logged me out, logged me back as, it logged me back as Judge Meyer.
But right here, it's okay.
Okay.
So you should put, go to your.
Okay.
Yeah, okay, so it should be good.
Okay, yeah, it keeps putting me back. Yeah, see, it's still in.
just, just showing the picture, but.
All right. Okay, that works. All right, Mr. Steele, your next court date, as I indicated, will be November 6th at 9 a.m. While you are out of pending your case, you are to, as I indicated before, appear timely at all scheduled court hearings, have no new law violations. Any change in your address or information must be made updated with DOL. You're not to drive without a valid license and insurance. Do not drive with a blood alcohol concentration above a 0.08 or any drugs impairing drugs in your system or a THC concentration above 5 nanograms. Have no new alcohol infractions. Do not refuse to submit to a breath or blood test if requested by law enforcement. Aside from that, I believe those are standard conditions. Counsel, anything I missed?
No.
Okay, so I will sign that and expect to see you here on the 6th. All right, we'll get you a copy of the paperwork and have a good rest of your day.
Thank you, Your Honor.
Thank you, Ms. Pleasant. All right, Mr. Haverco.
Oh,
Counsel.
on the arraignment typically, Your Honor, just might as well go ahead and go down the list, starting with item number 1 and just call it in. Just see if it-
Number 1's usually a good place to start, so let's do
Yep.
that. All right, is there a Brandon Mooney here? Oh, I'm sorry, I read the wrong name. Tammy Beach. Is there a Tammy Beach here? Oh, hi, Miss Beach. Please have a seat next to Mr. Haverco. All right. Looks like we are here for an arraignment. Counsel?
Judge Coker's colloquy usually wants to know income issues, so.
Oh.
I informally asked, and I kind of do it, but so anyway, she indicates she's not working right now, so.
Okay,
currently
so we don't, I was looking for that. We don't have a screening form. It's just,
We don't.
okay.
Yeah, so-
I'd rather not put too much on the record, but is your client,
She says she's not working.
is she getting social security at this time or unemployment?
Unemployment.
Okay. Well, for purposes of, well, actually, I'll make a finding and I'll sign an order indicating that you are indigent for purposes of representation. And we'll ask that I'll have the city of Yelm appoint an attorney for you today. Okay. That being said.
With that said, Your Honor, would stipulate to probable cause.
Okay.
And ask the court to enter not guilty.
All right. We'll accept your plea of not guilty. Conditions of release.
Standard conditions, Your Honor.
Okay. All right, so, and do we have a preference for a date, Mr. Avico?
Oh, pardon, Your Honor?
It looks like we have some choices of some dates here, October 23rd, November 6th, and November 20th.
I kind of refer to the clerk and.
Oh, okay. This is December 4th. Okay, so we'll schedule a court hearing for December 4th at what time? At 11 a.m. Okay. All right, so Ms. Beach, I'm going to set some conditions of release for you. It looks like there's agreement here. While your case is pending and you're out of custody, you are going to agree to appear at all your court hearings. Your next court hearing is going to be December 4th at 11 a.m. You are to have no new law violations while you're out of custody. Update any changes to your address with DOL. And most importantly, you're not to go upon the property or have any contact with Walmart. Is there a specific Walmart?
I think the one here in Yelm.
Okay, so we'll just indicate, if we can just indicate the Walmart in Yelm. Yeah. Yelm, Washington. Aside from that, that seems to be all the conditions. Council, anything else?
Nothing.
Okay, so that'll be the order today, and we'll see you back here on the 4th. All right, have a good rest of your day.
Does she need to sign the rights form? Okay.
And that's a good point. Council, I'll ask some questions regarding the rights as well, since we don't have that form signed. Perfect, thank you. All right. Oh. I'm sorry. I no longer have a signature anymore.
Can we? Okay, I'm having issues too, so maybe X out. Try refreshing and see if it then. I'm going really, really slow.
I can sign it with the mouse, but it's really turdy. Yeah. Let's try and make
Okay. So go ahead and exit out of that and then close the document.
release it.
Yeah.
I can just sign it with my mouse. That's fine.
Okay.
It's look
I might have to.
odd, but
Cookies if it's not gonna respond. See.
sorry, everyone. We're having just a little bit of a technical issue here with the software. Let me go back to the dashboard. Yeah, it's okay. It's usually this is usually what Courts does. Oops. Let's do that. Tell you what, I'll just move on. We can have it signed later. Yeah, and it did. Yeah. I'm just going to log out and log back in. Okay, I'm back in. All right, try it now. Got it. Yep. All right. I'd like to call Kevin, is it Bingaman? Is there a Kevin Bingaman here? Oh, please have a seat. Nice to see you, Mr. Bingaman. You are here for an arraignment. First, let's address whether or not, are you asking the city to appoint you an attorney? Okay. Mr. Haverco, if you don't mind having a quick dialogue with your client regarding his financial.
I'm familiar with Mr. Bingaman.
Okay.
He does qualify.
Okay, and does, so Mr. Bingaman, do you collect Social Security? Okay. In that case, based on your statements, I do believe you do qualify for appointment of an attorney at the city's expense, and I will sign an order if presented to that effect. With respect to the arraignment, Mr. Haverco, have you been served with a copy of the information?
Yeah, accept service, waive reading, stipulate probable cause as court to enter not guilty plea.
Okay, the court will accept the plea of not guilty on your behalf, Mr. Bingman. With respect to conditions of release, does the city have What is the city's position?
Your Honor, just standard conditions of Mr. Bingaman. Does have some other matters that are lingering, so.
Okay.
If anything else happened, the city would be requesting.
Okay. All right, so, Mr. Haverco, any objection?
Give me 1 second. What's the phone number? Okay, we've signed the form. I got his phone number.
Okay, any objection to standard conditions of release in this case? Okay, so, Mr. Bingaman, a not guilty plea has been entered for you, and that preserves all your rights. You will have trials scheduled within 90 days of today's date. In the interim, you will need to appear back here in court on December 4th at 10 a.m. here in courtroom 1. You're to appear in person while you are out of custody. You are to appear at all court hearings, have no new law violations, update your address changes or anything like that with Department of Licensing, and not, yeah, pretty much it. Abide by all conditions. And you are released. So I'll sign an order to that effect, and we'll see you back here in December, okay? All right, good luck to you. Have a good rest of your day. Go, signed. All right, so is there a Bridget Bowes? I might be pronouncing this wrong. Am I pronouncing it wrong? No. Oh, good. All right, Miss Bowes, please have a seat. Good afternoon. Looks like you are also here for an arraignment. Before we begin, are you requesting the appointment of an attorney in this case? Okay, sir, you're going to be hiring a lawyer?
No, I guess I do need one then.
Okay, all right. I'm going to have you have a quick dialogue with Mr. Haverco regarding your situation, and then we'll get some more. Okay, I heard that. Yeah. So you appear to be on SSI, is that correct? Okay. So based on that, I do believe you would qualify for the appointment of an attorney at the expense of the city, and I will order that. So we'll get you a lawyer. In the meantime, Mr. Haverco, have you received a copy of the information?
Yeah, stipulated probable cause as for gentlemen.
Oh, thank you.
Have a phone number? Have to sign something here. You're not going to do that to me. Sign this pad. It's good enough. She signed the form.
Okay. You acknowledge receipt of the information?
Yes.
All right, and are you entering a plea of not guilty on behalf of your
Yeah.
client? Okay, court will accept the plea of not guilty with respect to conditions of release. Counsel, what is the city's position?
Sorry, standard conditions.
Standard conditions? Okay, thank you. All right, and we're looking at a December 4th date as well. Okay. All right, Ms. Mooney. So, and I'm assuming you have no objection to standard conditions, Mr. Haverco. Okay, so I'm going to release you on your own recognizance, and we'll set some conditions of release. Basically, your conditions are going to be that you're to appear at all court dates on a timely. You're to have no criminal law violations. Update your address or any changes with Department of Licensing. Don't drive without a valid license or insurance. Did I miss anything, counsel? No. Okay, cool. So those will be your conditions of release, and you're going to be required to appear back here in court on December 4th. Okay. And you'll get a copy of that, that order as well. All right. So we'll see you back here December 4th at 11 a.m.
You go to the front window.
All right. Good luck. Have a good rest of your day. All right. Next we have, let's see here. So it looks like we actually had two cases for Miss Bose, or they're just two charges under the, oh, it's the same cause. Never mind. Next I have a Megan Brown. Is that what you have, counsel? All right, Miss Brown, please have a seat. Good afternoon. Are you going to be requesting that the court appoint an attorney in your case?
Yes, Your Honor.
Okay, so I'm gonna have you have a quick conversation with Mr. Haverco.
Currently, she's not working at this time.
Okay, and no other sources of income?
She gets assistance by way of food stamps.
Perfect, okay. And based on that statement, I would find that you qualify for appointment of an attorney at the expense of the city, and I'll sign an order to that effect, or I'll order that here. With respect to the arraignment, counsel, have you received a copy of the information?
Yeah, accept service, waive reading, another complaint, stipulate probable cause, as to court to enter not guilty plea.
All right, sounds good. Conditions of release.
Standard conditions, Your
Standard
Honor.
conditions. Okay, thank you.
We just ask that Ms. Brown doesn't return to the scene of the alleged theft.
Okay, is that listed here in the, I'm looking if that's listed in the, it's not listed in the proposed order. Is there a specific location? So I could order that, but I kind of want to make sure that she has it in writing so that there's no confusion. Is it also the Walmart?
It's the wall.
Okay. All right, so. Sorry, Ms. Brown, real quick. I'm going to release you on your own recognizance. Standard conditions are going to apply in this case. You are to appear timely at all your court hearings, have no criminal law violations while this case is pending. Any changes in your address, you need to update with Department of Licensing so the court knows how to get a hold of you. And the additional condition here is that you are not to go or have contact, go onto the property of or have contact with the Walmart here in Yelm. Do you understand that? Okay, so with that, I will sign this order release, allowing you to remain out of custody on your own recognizance. And you're going to be required to appear back in court on December 4th at 10 a.m. All right. All right, good luck to you. Have a good rest of your day. We'll get you, I go to the window, you'll get a copy of the order. So. All right. Next, is there a Kevin, is it Carmona? Am I pronouncing that right? Kevin Carmona? Kevin Carmona? Okay.
Despite the non-appearance, Your Honor, the city is going to be attending this no on the second.
Lucky guy. Okay. Do you want me to accept, do I need to accept an amended information or anything like that? Or?
And third, what would you prefer?
I think it's just an order. Oh, okay. Okay. Okay, so let's do that. Mr. Haverco, I'm assuming you have no objection to a reduction to a no all. Okay. All right, thank you. Thank you, counsel. That's lucky for him. Let's move on to Leah Cox, or is it Leah? Leah? Yeah. Leah? All right, Ms. Cox, have a seat, please. Good afternoon. Are you going to be requesting that the court appoint an attorney in your case?
Yeah, or a second scale or something.
Okay. Have a chat with Mr. Haverko and then I'll ask some questions.
You want me to say an amount out loud?
Let me ask this. Are you employed right now, Ms. Cox? Okay. And do you support anyone on your income?
No.
Okay. All right. Mr. Haverko, is that income, monthly income greater than $2,000 a month?
No.
No? Okay.
Is that the threshold?
It's a little lower than that, but I think that's where we're gonna go today.
Okay.
Okay, so I'm gonna appoint you an attorney at the city's expense. With respect to information, Mr. Haverko, have you received?
Okay. So accept service, waive reading of the complaint, stipulate probable cause as court entered not guilty plea.
Okay, sounds good. The court will accept a plea of not guilty on your behalf, your attorney's plea of not guilty on your behalf, Ms. Cox. And we'll go to conditions of release. What is the city's request regarding conditions?
Your Honor, standard conditions and that Ms. Cox doesn't return to Walmart in this action.
Okay. Again, that's not in the in the proposed order, but Madam Clerk, if you don't mind including that in there. All right. So Ms. Cox, we're going to set some conditions of your release. You are going to be allowed to remain out of custody on your own recognizance. It's going to be important that you appear at all your court hearings. You're to have no new law violations while this case is pending. You are to update any changes to your address with Department of Licensing. So if the court needs to get a hold of you, they can do that. You are to have no contact with or go onto the property or have contact with the Walmart here in the city of Yelm. Do you understand those conditions? Okay. So with that, I will sign on those conditions. And your next court date is going to be December 4th. And is at 11? Okay, at 11 a.m. All right, good luck to you, ma'am. And I'm just kind of.
Go to the front counter. Okay. Good. Yep.
Let's make sure. Sorry, I'm having some issues with the signature not working again. Okay. All right, order signed. Thank you. All right, next I have a Michael Cunningham. Hello, Mr. Cunningham. Are you going to be requesting that the court appoint an attorney in this case?
I might.
It might or do?
I think the city's probably going to
The city's moving to amend to no problem.
Ah, okay. All right, Mr. Haverko, I'm going to give you just a quick opportunity to explain to Mr. Cunningham what that amendment means.
So what you do is you admit, so he'll admit to the infraction.
Okay.
And it's usually $150.
Okay. Are you good with that?
I guess.
Okay, I did overhear. It sounds like you're making some progress in getting back your license. That's awesome, man. Yeah, I'm glad you're doing that. That's really good. So this is a good outcome. It's not a criminal charge, it's an infraction. So you're lucky the state's agreed to do that here. So you can go to the window and
How long do I have till I have to pay that off?
I'm gonna defer to council.
That'll be perfect.
Oh, okay. Yeah, let's do that. And obviously, if you want to pay it off quicker, even better, right? But yeah, we'll have you check in with the front desk and set that up, and I think you should be good. All right.
No.
Yeah, no worries. Good luck to you. All done. All right. Right, next, we've got a Charles Doan, D-O-A-N. Doan. Number 9 on the calendar.
Well, there's a docket note.
Request for RIS.
Request for a reset.
Ah, okay.
So you either call or send a note or send an email.
Okay.
So, you know.
I don't have a problem with that, particularly given the, well, I was gonna say the charge, but let's do a reset then. Are you aware of any requests for how long that reset needs to be?
No, I don't know. It's whatever was in the note.
Okay, does the city have any objection to setting this over?
No, maybe let's just go 4 weeks.
Okay.
Yeah, there's plenty of time for. If that works, then I think, yeah.
Cool. Do I need to sign something for that? It's just automatic. Okay. Well, that was easy. Okay. Is there a Caitlin Flagg here? Miss Flagg? Hey, Miss Flagg, please have a seat. Good afternoon. Looks like you are here. Initially, looks like the state has charged a driving suspended in the 3rd degree. Does the city have a motion?
Yes, Your Honor, city here.
Okay. Mr. Havico, do you have just could you just have a minute and explain to Ms. Flagg what that means?
So, yeah, she agrees with that, would it make an admission?
Okay.
$150 cost.
Okay, I will find that infraction is committed and impose the $150 court cost on that, or the fees on that. And I guess we just send you over to the front desk and you can set up a payment schedule with them. All right. All right. Good luck to you. All right. And then I have a Christine, is it Folkerth?
Yeah.
Hi. Folkerth. Okay. Please have a seat. Looks like you are also here for charge of driving suspended 3rd degree. Is the city making a motion to amend? Okay. And Mr. Haverco, could you inform Ms. Folkerth of what this means? Yeah.
Yeah, she agrees with that.
Okay.
Admits to the violation, $150 cost.
Okay. Sounds good. All right. I will accept your stipulation to the infraction and find that it is committed. And I'll let you go up to the front and you can figure out a payment plan on the $150. So good luck to you. All right. Next is a Lee Furtwängler. All right. Good afternoon, Mr. Furtwängler. Before we begin,
I already represent Mr.
okay,
Wangler on the same charge. from
Okay.
About 2 weeks ago.
I was gonna say, I think I may have represented you in the past, have I?
Maybe for like way back.
Yeah. You don't have any, I don't fully recall, the circumstances of your case. Your first and last name seem familiar. But at this point, unless anyone has any objection, I'm comfortable proceeding with the arraignment.
No objection from the city.
Okay.
especially if the city
Okay.
proceeds.
All right, Mr. Habaco, is
No-
that
no
okay?
objection.
Okay. All right, so with respect to appointment of counsel, Mr. Habaco has indicated that Mr. Furtwängler is already represented by the city. Has your financial situation changed in the last few weeks?
I mean, yeah, I don't make as much money as I said I did last time. but-
Okay. Okay, so it doesn't sound like your situation has gotten any better since the last time you were appointed counsel. Is that fair to say?
Oh, yeah, no.
Okay, so I'm going to appoint Mr. Haverco again in this matter as well. With respect to the charge of driving with license suspended second degree, what is has your client, or have you received a copy of the information?
Accept service, waive reading of the complaint, stipulate the probable cause, ask the court to enter not guilty plea.
Okay. All right. Court will accept the plea of not guilty for the charges on Mr. Furtwängler's behalf. With respect to conditions of release, what is the city's position?
Standard, Your Honor.
Okay. Just a moment. Mr. Haverco, do you have any objection to the city's request
No.
for standard conditions?
No.
Okay.
When do you think your next court date is on your other case?
All right. That makes sense. All right. It says November 20th. Oh. I had October 29th. So it's November 20th is the other case? I thought it was October 29th.
Should be November 20th at 11 a.m.
Okay. So you're going to be required to reappear here back on November 20th at 11 a.m. I will release you on your own recognizance. Standard conditions apply. As I've indicated before, you'd appear at all court hearings. You have no new law violations while this is pending. You're to update any changes with your address with DOL. And more importantly, you're not to drive without a valid license and insurance. Any questions about those conditions? Okay, I'll sign that conditions and we'll see you back here on the 20th of November. All right, good luck to you, sir. All right. All right, is there a Daniel Hamilton here?
Expecting non-appearance, Your Honor, city will be moving to New Orleans.
All right. I will accept the amendment, obviously. I guess the court will have to notify him of the infraction and then he'll have an opportunity to address that later. Okay. All right. Thank you, counsel. Let's go here. We have number 15. Am I on the right calendar here? Number 15 on the calendar. Is there a Stephen Linford here? Mr. Linford? Looks like there is a note here. Looks like he is represented by Mr. Woody on another case I see, and he has a court date on the 23rd. It would appear, can we note Mr. Linford's non-appearance today? And then provided there's no objection from the city, I just asked we could set this on for the 23rd Okay, any objection, Mr. Haverko?
No objection.
Okay, so let's do that. There's quite a bit on here. Yeah. You're gonna need a minute. Okay, I'll give you a minute. I keep flipping and it's still him. All right. Yeah, something like that, yeah. So let me know when you're ready to start back up.
Oh, yeah.
Oh, you're good? Okay. I'd like to call a Haley Longmire. Is there a Haley Long? Hello, Miss Longmire. All right, so it looks like we have yeah, okay. Mr. Haverko, if you could explain to Ms. Longmire what an amendment on that driving suspended third to a no vol is.
Yeah, she likes that idea. So she
All right.
can admit to that violation.
Sounds good.
Yeah, I'm okay with that.
Sounds good. We'll do that. I'll accept the finding of committed for that infraction. I will note there is another tracking infraction for speeding. Is the city gonna make a motion on that or?
The city would just recommend, that the fine also be one.
Okay, well, let me ask, Mr. Haverko, if you could, as a friend of the court, if you could talk to Ms. Longmire about that infraction. I'm not sure. I'd have to look and see if she qualifies for deferred on that infraction, if she wants to do that. Yeah.
Is that within the time?
It's 7 years. So it's just outside. So you got some options. Well, you can defer. Which means. She'd like to defer it.
Okay.
Sure.
And it sounds like you just qualify. And it sounds like you were successful previously on your deferred. So hopefully that'll be the same thing here. Typically that's what, $75? What is the deferment cost? 4-month deferral. Jeez. Okay, man, you were lucky. All right. The court here is way too nice to deferreds. Okay, so 4-month deferment, it's $100 for the deferment. So in addition to the infraction of the no vol, that's $250. You can set up a payment schedule on that. However, the deferment is only for 4 months. So I'm assuming that $100 must be paid before the end of that deferred. So the court will accept a deferment, provided the city has no objection. Okay, so we'll do a deferment on that, and you can set up a payment schedule with the court clerk. Okay. All right. Good luck to you.
Hey, Your Honor, would you mind this number 34? I got thinking about it, Mr. Jack Terry. He arrived early to court. I think he probably got to court here around 11 o'clock.
Oh, man. Okay, what number is he again?
Yeah, it's number 34. It's Jack Terry.
All right.
I was thinking if Your Honor wouldn't mind maybe taking him out of order because he's
Yeah,
been sitting
man, let's
here
do it.
for at least a couple hours.
Yeah, of course. Mr. Terry, please have a seat. Good afternoon, sir. Looks like you are here on one count. Are you requesting that the court appoint an attorney in your case? Okay, Mr. Habaco, if you could have a quick dialogue with him.
He's on food assistance.
Okay.
No,
don't have to say anymore.
And not working.
Okay. Based on that, Mr. Terry will find that you qualify for the appointment of an attorney at the expense of the city. And
Accept
we'll
service
order
of,
that.
waive reading of the complaint, stipulate probable cause, ask the court to enter not guilty plea.
All right. So on behalf of your client, I'll accept a plea of not guilty for Mr. Terry. With respect to conditions of release, what is the city's position?
Your Honor, standard conditions.
Okay.
No objection.
Okay. Let me go back. I apologize for all the waiting. The software is a little bit slow today. It's taken some time.
Yeah, it is.
All right. All right, Mr. Terry, I'm going to set some conditions of your release here. You're going to be released on your own recognizance. You're going to be required to appear at all court hearings, have no new law violations, any changes your address. I'm going to expect that it gets updated with Department of Licensing so the court knows how to get a hold of you. You are not to go onto the property or have any contact with the Walmart here in Yelm. Any other conditions, counsel? No. Okay. You are going to be required to appear back here in court on, would that also be? Okay. Now it's on there. December 4th at 10 a.m. here in this courtroom. Okay. So I'll sign the order and you can grab a copy over at the window. And, oh, sorry, I'll wait for you to sign it, Mr. Habaco. Go and I will sign it.
The software is a little slow today.
Yeah.
My signature box is not opening up.
Yeah, same thing's happening. It does. Yeah. I'll just refresh it. Just refresh.
There we go. Okay. We sign it.
Okay. I've signed it as well. All right. Okay. Good luck to you, sir. And thank you for coming on time today. Okay. Have a good rest of your day. All right. Back to top of the list.
Number 26, Muscott.
All right. Shannon Muskoff. Hello, Miss Muskoff. Are you going to be requesting that the court assign you an attorney, appoint you an attorney?
Yes.
Okay, so Mr. Habaco, if you could please have a quick exchange.
She's on Social Security disability under 2,000.
Okay, and based on that, I would find that you qualify for the appointment of an attorney. And we'll order that in this case. Mr. Habaco, did you receive an information to Ms. Muscott?
Service of, waive reading of the complaint, stipulate the probable cause, support to enter not guilty.
Okay. Does the city have any requests regarding conditions of release from Ms. Muscott?
Just.
Okay.
Let's see.
All right, Ms. Muscott. Oh, I should say, Mr. Habaco, any objection to
No.
PR release, no contact with the neighbors? Okay.
No.
All right, so I'm going to release you on your own recognizance, Ms. Muscott, while your case is pending. You're to appear at all court hearings, You're also to have no new law violations while you're out of custody. Any changes in your address, you must notify DOL so that we know how to get a hold of you if we need to. And most importantly, the most important condition of release is that you're not to have any contact or go onto the property of a summer hawking. And if you do that, that could potentially violate your conditions of release, and you could end up having to wait for this case in custody. Yeah. Yeah. So just to clarify, this is not a no contact order, but this is a condition of your release. So if you were to violate this by having contact and law enforcement is notified, or the court is aware, or the city is aware, they could move to revoke your conditions of release. So I don't believe I am, counsel, I'm not signing a protection order today, but I am going to order that you not have contact with her, okay, as a condition of your release. All right, so I'm going to sign that, provided there's no objection. Your next court date is going to be on November 6th at what time?
Oh, okay.
So, and we have another case on the same day. Fighting another person.
Cool, okay, so that's what we're gonna do. Are you okay with that? All right, we'll see you back here on November 6th at 9:45 a.m. And you can get a copy of the conditions of your release on your way out at the front desk, okay? All right, thank you, Mr. Haverco, I got that.
Yeah, so go ahead.
It's unlocked me.
Go to the front
Okay.
counter.
I'm just hanging on the signature. Let me give you a chance to do that first. I'm gonna refresh. I'm gonna let you sign it first if you can.
Well, I guess we can skip my signature.
It'll work. Just she knew why it does that.
It's never really done, I mean, it's kind of done that briefly for a second too, it's never froze for this long.
Well, I'm wondering if we're both trying to sign at the same time, and that's maybe what's doing it. I'm sure. Try this again. Okay. Signed. All right, so after Ms. Muscock, who do we have next? Looks like we have number 27 on the calendar. Is it Plasencia? Aravello? Plasencia Aravello? Juan Stavo? Valencia? Nope, okay. Mr. Haverco, do you have any information about Mr. Palencia?
I'm never gonna have information on the arraignment. Those are the
Okay.
arraignment folks, 'cause
And we didn't receive a call, Madam Clerk, or anything? Okay. Okay, counsel, what would the city like to do in this case? All right, Mr. Haverco.
I take no position.
Okay, well, I'm not a big fan of issuing warrants, but I guess without any additional information as to why Mr. Plasencia is not here, I am going to grant a bench warrant for a failure to appear. And notice has been sent can you make a record, counsel, regarding notice of this hearing?
Yes, Your Honor, I have no reason to believe that the notice was not sent to, Mr. Valencia Arevalo.
Okay, and that was his last known address? Okay. Okay, well, then I will issue a bench warrant in the amount of $500 for his appearance. So it is bondable. Let me see, is there an order? Oh, okay, I'll sign it later then. Okay. All right, moving on. Next we have Santos Campos. Anais, or is it Anais? Okay. Well, good afternoon. I'm sorry I butchered your last name. So you are here for a driving suspended third. Is the city going to make a motion in this case?
Yes, Your Honor.
Okay.
Yep, city's moving to amend to no law in a second.
Okay, and Mr. Haverko, if you could please consult with your client.
So she agrees with that?
All right.
Would admit to the violation?
Okay, I will.
To $150.
Okay, I'll accept the state's motion to amend to an infraction of no valid operator's license on person. And we will, I will accept, accept Ms. Santos Campos's stipulation and find that she has committed the infraction and order that $150 court cost fee be imposed. And you can set up a payment plan with the court clerk on your way out. So good luck to you.
Thank you.
All right, I hope have you been working on getting your license back?
You know what? I just got it about 8 months ago.
Oh, good.
I never knew it was suspended. I don't know.
Okay.
What it costs.
Okay. Okay. Well, yeah, I'm glad you're on top of it. So,
Yeah.
All right, good luck to you.
Thank you.
So it looks like you've got maybe, not sure if this is correct, but you may owe $986.
Yeah.
First County District Court for $202 to.
It's usually unpaid tickets is what gets you.
For tickets?
That's probably what it is. Could be an
That's what's
per
suspended
cost.
license.
Would that be my driver's license for me to get it? Because I just got it like 8 months ago for the very first time.
So you also are suspended right now, failed to comply with financial responsibility. And you're suspended until 12/13/27. You need to talk to you.
Okay, well,
Yep.
okay.
Yep.
All right, good luck to you. All right, moving on. Is there a Barbara Scheibel here? Scheibel? I mispronounced that. How do you pronounce your last name, ma'am? Scheibel? All right, Ms. Scheibel, thank you for being here. Are you requesting that the court appoint you an attorney to represent you on this matter? Yes. Okay, so Mr. Haverko, if you could please have a quick colloquy with Ms. Scheibel and see what her financial situation is. Because I think part of it is being on the record, it's financial disclosure. It's protected information.
Sounds good. This is
Just okay. Yeah. Well, it's also informal. Yeah, that's fair.
Well, they're all.
It's just,
This is back from May.
yeah, I have some examples I can send you guys if you want.
Yeah, so she's on Social Security disability.
Oh, okay.
So I believe she probably qualifies for court appointed counsel.
If that is the case, I do believe you would qualify, Ms. Scheibel, and I'm going to appoint you an attorney at the city's expense to represent you on this matter. With respect to the hit and run charge
Yeah.
unattended, Mr. Haverko, if you could.
Yeah,
please.
as to all three cases, two of which are the same as accept service of the complaint, waive any further reading of it.
I see.
Stipulate to probable cause and ask the court to enter not guilty pleas on all charges.
All right, well, I'll accept the plea of not guilty on your client's behalf. And the court will address conditions of release. It looks like we actually have two separate cause numbers. So I'm assuming.
There's actually three.
Oh, am I?
Yeah, there's three, and two of the matters are just driving and non-driving. So same.
Yeah, I see two on the calendar, one ending in 793 with 2 counts, and then one ending in 1470. Am I missing another one?
So if you look at, it's item numbers 29, 30, and 31.
Yeah, that's what I'm looking at.
So
29 and 30 are the same cause.
Ending in 286, 287, and ending in 017.
Oh, I'm sorry. I'm looking at the wrong. My bad. I'm looking at it at a different number here.
Yeah.
Must be the arrest number. My apologies.
No
I see
problem.
exactly what you're saying. So we'll enter pleas of not guilty in all three matters. Is that
Yes,
correct, Mr.
yes,
Haverko?
yes, sir.
Thank you. Appreciate you bearing with me there.
No problem.
Okay. Does the city have a position regarding conditions of release for those cases?
No, Your Honor, just request conditions.
Okay. Mr. Haverko, any objection to standard
No
conditions?
objection.
All right. So let me pull up that proposed order. All right, Ms. Scheibel, it looks like the court will be releasing you on your own recognizance. So you'll be out of custody while this is pending. You are to appear at all court hearings. And while you're out, you're to have no new law violations while this is going on. Any changes in your address or any updates need to be made with department licensing so we know how to get a hold of you. Other than that, is there any additional conditions? I noticed there's a trespass. Oh, no, I'm sorry. I'm looking at the wrong thing. Okay, no worries. That looks like those are the conditions. Counsel, is that correct?
That's correct.
Okay. So you are to be returning to court on December 4th at 10 a.m. And we're going to set all three of these matters on the same date. So they're going to track together. Okay. All right. All right. I'm going to sign that order and we'll see you back here in December. Any questions? Okay.
I'm going to see if Oak Courts will let me.
Yeah, I'm gonna
sign.
stay out of it. I'm gonna let you do
Well,
your signature first, and then we'll see.
You know, I don't know that it should really matter because I think Your Honor can.
I feel like when we're both doing our signatures
I
at the
don't
same
know.
time, it locks up.
I mean, because I am able to sign after you sign. It won't let me change anything, but it'll let me
Yeah.
sign.
Oh, here we go. I think I'm good now. Let me try it. Yep. All right. Signed it. Cool. Okay. So you should get a copy of that, Ms. Scheibel, at the window over here at the clerk's office. Okay.
Yeah, I'm able to sign after you do your.
Okay.
Yeah, except it won't let me sign because it won't open up the
Oh,
signature dialog box. It's freezing. So you're free to go. Just go up to the window and see the clerk before you go. And she'll give you your paper with the clerk. Yeah.
all right. Good luck to you. All right. Next, I have a Jessica Shea. No? Is there Jessica Shea here? Looks like we have two people in the courtroom. What? Who's here for court? Humphrey. Okay, Miss Humphrey, come on up. Have a seat. We're going to take your case now. Oh, is it 2:30? Well, I'm sorry. Maybe we can. I apologize. We're going to finish up on the one 1 o'clock calendar, and now you'll be right after that, I promise. Sorry about that.
That appears to be all the 1 o'clocks that are here, Your Honor.
Okay, well, we've got the Shea, Jessica Shea is not here.
Gotcha.
How do we want to proceed with that?
Your Honor, I'd say maybe we just, there's a note in the file that says set me for alpha.
She must have another case.
Yeah, I think we just reset.
Yeah, no appearance today.
Okay.
Just send it over to the, yeah, I probably represent on the.
I think that makes a lot of sense. Let's reset it to match with her other pending matter on 11/6 at 11 a.m. And then finally, I have one left here, a Travis Umtouch, number 35. And do we send notice to Mr. Umtouch? And he was provided today's date, eh? Okay. Well, in that case, I don't have any issues unless Mr. Haverco, any basis to object. All right, I'll sign a warrant for failure to appear, and we'll set the amount of $500. Okay. All right. And I believe that concludes our 1 o'clock calendar. Ooh, with 12 minutes to spare. Great. Do you need to take a break at all? Are you sure? Okay. All right. Do either council need to take a break before our 2 o'clock? Would you like an opportunity, Mr. Haverco, to speak with Ms. Humphrey?
Your Honor, 2:30 calendar is actually.
Oh, infraction.
Yeah,
Right.
infraction.
I see.
Right.
And actually, I don't appear for the city either. Sometimes I stick around and observe, but
Okay.
no argument.
All right. I'll tell you what. Let's take a brief recess then, and we'll come back in about 10 minutes. right, thank you. We are on the record. We are here today for the infraction calendar, the 2 p.m. infraction calendar here in the city of Yelm. My name is Eric Pilon. I'm the pro tem today. Good afternoon, everyone. There will be some options here today for all of you. One, you're going to have the option of, you have 3 options. 3 things that we can do today with your infractions. One, you can ask the court to mitigate the cost of the infraction. So you can ask the court based on financial hardship and based on your record, you can ask the court to mitigate or reduce the cost of your ticket. Secondly, you have the option, if you are eligible, and I believe at least one of you may be eligible for what's called a deferment or a deferred ticket. So in that case, it's a $150 fee, and your ticket is deferred for 4 months. If you have no infractions, then the ticket is dismissed. And then there is also the option of contesting the ticket. So if there is some factual basis, or if there's an issue with the way in which the speed measurement was taken, or if there is some issue with the ticket itself that you think means that you did not commit the infraction, that is something that we can hear today. Okay. So that being said, I'm going to start with the top of the calendar. In fact, actually, I'm going to go with Ms. Humphrey. I know you've been here since the 1 o'clock calendar, so please come and have a seat up here. Now, Ms. Humphreys, how are you asking the court to address your infraction today? Okay. Let me see, I'm pulling your ticket up here. Does appear you would be eligible for a deferral. Now the deferral, and that would be on the speeding ticket. Okay. So on that matter, it would be a $150 fee. So you'll need to pay that to the clerk. You're going to need to pay that within 4 months, because if you're able to go 4 months without any new infractions, speeding tickets, that kind of thing, then this matter will be dismissed. Okay. If you get another ticket or you don't pay the fine, then when 4 months comes around, or if there's a violation, you will be found committed for the ticket, and you'll be responsible for the full cost of the ticket. Do you understand that? Okay. So with that, I just want to double check with the clerk. It does appear on the calendar that she would be eligible for deferral. Okay. So I will accept that, and we'll put you on a deferment. So I guess we'll send you over to the clerk's window, and you can pay your $150 fee or set up a payment plan on that. And then hopefully we won't have to see you after that. You'll get this dismissed. All right. Good luck to you. Thank you for being so early today and being patient. So have a good rest of your day. All right. I'm just going to put them here when I'm done. So, all right. So top of the list here, we have a Luke Baker. So Mr. Baker, please come have a seat. So Mr. Baker, give me just a second. I'm going to pull your ticket here. All right. So it looks like you were cited for two infractions. One, operating a motor vehicle without insurance or proof of insurance, and possessing a vehicle without registration as well. Were you able, how would you like to deal with that today?
I've been trying to use
Oh, you do have your registration? May I see that, please? You can approach. It's all right. You can have a seat. I'll give it back to you, I promise. Vehicle ID number matches. Great. Thank you very much. Put that back. All right, so, and you don't have your insurance. Yeah, okay. Okay. You couldn't afford your insurance? Okay. All right, so how do you want to proceed today? It looks like you may be eligible for a deferral. But that would be $150 or I could mitigate the costs on these matters. How do you want to proceed? Okay, I'm going to do this. Since you've brought in proof that your vehicle's registered, I'm going to dismiss the operating vehicle without registration and the penalty associated with that. But I am going to find that you've committed the offense of, or the infraction of operating a vehicle without insurance. The fine on that, as you know from your ticket, is $564. I'm going to reduce that fine based on the dismissal. I'm going to set that fine at $150. So I'm going to ask that you, I'm going to find that you committed that infraction, and I'm going to order that you pay the infraction fee of $150. Okay. All right. Madam Clerk, is that okay if I can have that reflected in the? Okay. All right. All right, so we'll prepare an order. It'll get up to the front, and then you can set up a payment schedule on that $150. Okay. Okay. All right. All right. Next, I have Caleb Bowman. Let me see if I can get your paperwork. Do I have anything from Mr. Bowman? I've got this guy. I've got these are done, and then I have this other one here. Really don't have anything for Mr. Bowman. All right, Mr. Bowman, we're going to recall your case in just a minute. We're going to locate your file, and then we'll address this. Okay. You're totally fine. Thank you. All right. All right, Mr. Bowman, please come on back. All right, so it looks like you're here because of a speeding ticket. All right, how would you like to proceed today? Okay, it does appear, my note does appear that you had either called in requesting if you, or to determine if you were eligible for a deferral. I would say that it would appear you are eligible for a deferral. Okay, so I can advise you this way. The cost of the ticket in this case is $217. I can reduce that ticket. I'll reduce it to $150. Or if you'd like to do the deferment, it would cost $150, and then you'd have to not have any infractions for 4 months and pay the $150 before the 4 months are over, and then the ticket would be dismissed. So I think those are two valid options, and you could also contest the ticket. But again, okay, so how would you like to proceed?
I guess without being said, I think I'd be able to.
All right, so it's going to be $150 for the deferral, and I do, it does indicate on here he's eligible, so I'm assuming that's correct. Okay, so based on that, I'll grant the deferment of this infraction. It's going to be for 4 months. Like I said, no tickets. Drive like an old lady for 4 months. Okay, we'll keep doing it. And then you can set up a payment schedule, or if you can just pay the $150, then you won't have to worry about it, but it needs to be paid before the end of the 4 months. Okay. All right. Good luck to you. All right. So next person, I have a Brian, is it Cornodal? Okay. I didn't butcher that, did I? No. Cornodal. Okay. And it looks like you originally were charged with a crime of driving suspended in the 3rd degree. And it looks like the city made a motion or amended their charge to a no valid operator's license with no valid operator's license on person with valid ID. That is an infraction. That particular infraction carries with it, and I've pulled up the statute here, it carries with it a standard $250 fee. How would you like to proceed today regarding that infraction? Okay, so okay, so okay, before we, so here's what I'm going to say. Thank you. No, I'm glad you told me. I was going to inquire. So one of the things that you would have to present to the court would be some evidence that at the time you were stopped by the officer. So back on, when did this happen? Back on August 14th of this year, you had a valid driver's license. Your license was not suspended. It was a valid license. Hang on. So if you're able to show that, hang on, I'm trying to help you, man. If you're able to show that, then I think we should contest this. Go ahead and show me what you got. Otherwise, if that were not the case, the statute's pretty clear as to if your license was suspended at the time, that would be sufficient for this particular infraction, right? However, the statute does allow also that if you were able to get your license and come to court with proof that you are now validly a holder of a valid license, I am authorized to reduce that $250 fee. In fact, the legislature says the court shall reduce the penalty, meaning I must reduce the penalty to $50. So I'm just going to advise you about that. We can go ahead and start, kicking in doors here with this charge, which if you had a valid license and you can prove it, we can verify it in the system. But at this point, there was at least some indication on the part of the officer when he ran your information that you were in fact suspended. All right, hang on, before you start explaining to me the misunderstanding, if you want to proceed with the contested, but hang on, before I see any evidence, you need to tell me you want to proceed with the contested, and we'll do that. But I mean, I'm looking at the sworn statement from the officer, so unless you're able to show me an actual non-suspended license on August 7th.
Can I say something?
Sure.
So what had happened is, he went and he got his license, they issued him a license. And the letter was sent to his old address, so he was under the impression that his license was valid.
Okay, so hang on. So we're going for the basis of the contesting. Yeah, and again, before we go into the contesting, the fact that you were unaware that you were suspended is not a defense either. No, you can, but it would be, okay.
But I do want to contest the negligence.
Oh, there was also a negligent on here. I don't see that. I only have this on here. So I don't see it. Is there a separate ticket? Okay. All right. Well, that's a different story. So let's do this.
He said I was.
Okay, wait, hang on. No, I do want to hear what you're saying. I don't mean, yeah, if I just, it's like you're breaking the glass for the contest hearing. So before we do that, could you show me your license, please? We'll get to this, I promise. Let me just take a look here.
I just had a justification purpose because it's due to child support, but I don't know child support anymore. The state support.
So you don't, do you have a temporary license or something? Oh, this is a temporary. Oh, I see. This is your temporary document. Carry this until you receive your new one.
Because I had a valid license, but they punched it when I got that one.
Okay, that's fair.
Instead of being in the mail in 2 weeks.
All right, have a seat. I'm gonna have the, I need a little bit verify. Makes sense.
My document.
So here, you can have this back. And the statute is pretty clear. You've presented me with a license, a valid license. I shall reduce your penalty to $50. Okay, so that one is taken care of. So let's shift gears to the negligent driving second degree. I'm gonna pull that up. Grab the citation. Okay, give me just a moment. All right. Are you contesting this? All right. I'm going to dismiss this ticket. The infraction indicates that officer was parked facing the west corner of Rainier View Drive Southeast. He observed your vehicle, a black Harley Davidson, traveling southbound on Wilkinson Road Southeast and passing another vehicle at an extremely high rate of speed at 25 miles per hour in a residential zone. Based on that, he activated his lights and conducted a stop. The statute for negligent driving in the second degree indicates a person is guilty of negligent driving in the second degree if, under circumstances not constituting negligent driving in the first degree, he or she operates a vehicle in a manner that is both negligent and endangers or is likely to endanger any person or property. is an affirmative defense, negligent driving in the second degree. It must be proven by the defendant by preponderance of the evidence that the driver is operating the vehicle in a private property. All right, regardless, the only information I have regarding your driving behavior is that you were operating past another vehicle at an extremely high rate of speed in a 24-mile-per-hour zone. Now, if that extremely high rate of speed was 70 miles an hour in a 24-mile-an-hour zone, I would say that is negligent. If you are going 40 miles an hour in a 25-mile-an-hour zone, that's not safe. But I mean, does it raise to the endangerment or likely to endanger a person or property going 15 over? Yeah, it's getting there, but not. That's a question. That's the point. So I think the extremely high rate of speed certainly could constitute negligent driving, but I think I would need additional information. The passing another vehicle, did you cut the vehicle off, or so that you don't have to give me any information, but I mean, there's not really enough to show the negligence, the risk to property or to endangering others. But I am concerned about the extremely high rate of speed. Like that certainly could be if there were more information in the sworn affidavit. So I would just say you're very lucky. Slow down. Especially if you're just you don't have to share it. It's all right. Just you don't want to keep adding to the facts. But the point is, I think this is a deficient fact scenario to support the negligent driving. So I'm going to dismiss the ticket. But that being said, just slow down, be cautious, be careful. I know weather's kind of changing. Maybe it's not so much motorcycle season now, but I mean, when it is, be careful. If not, for yourself. Okay. All right. Hey, have a good day. So you can set up the $50 payment on the other ticket with the front desk, and that'll be it. All right. You too. Talk himself out of a dismissal. All right. So looks like we have one person left in the room. Let's just go down. Is it Bridget Saxton? Is it Saxton? Yes. Please come on up. So you've got a speeding ticket here going 18 miles per hour over the speed limit. Oh no, I'm sorry. Yeah, 18 miles over the speed limit. So how would you like to proceed today?
If I'm eligible, I don't believe I've ever had a speeding ticket before. I mean, I've got some other stuff, but I've never, not speeding, that's not my jam.
Okay. Well, you are eligible for a deferment, for deferral of this. So it is $150 for the court costs. And that's going to be a deferment for 4 months. So you're not to have any speeding tickets, get in any trouble, any traffic infractions for the next 4 months. And provided that's the case and the $150 is paid, this infraction will be dismissed. Do you understand that?
Yeah.
If you don't, it will be committed.
I was absolutely speeding that day.
Well, you don't have to tell me. You got a deferral. So it's on you to drive safe and hopefully this will be the end of it. So you can set up the $150 payment with the front desk. Okay. All right. No worries. All right. Good luck, Ms. Saxon.